Check 1 2. Check, check, check. Audio check 1 2.
Can someone go outside, tell everyone to come inside? All counters to be closed. So friends, I welcome you to this post-lunch session. The topic seems to be general, session on corporate laws. Corporate laws, very wide subject, varied subject, so many components of corporate laws. At least in India, about US, we will know more about, you see, from Mr. Jaipat Jain. But this session is unique for the reason that the emphasis possibly you will not find in any conference. What is the topic? It is lessons from deals that failed. So what are the lessons from the deals that failed? It is inherent in this session that when we are talking about deals which failed, we are also thinking about how to remedy the situation, how to bring about solutions, you see, which are possible if the deals have failed. We have very, very eminent panel here, headed by, excuse me, Mr. Jaipat Singh Jain, who is senior partner in the very famous law firm in New York, Lazare, Potter, Gavikos and Moyle LLP, New York. Followed by Mr. Amit Agarwal, senior partner, SNG and Partners, a very well-known reputed firm having its offices all over India. And Mr. Anil Kasuri, senior partner of AZB and Partners. I think this does not need any introduction at what AZB stands for. And of course, we have from one of the most distinguished law firms, that is Naik and Company, Mr. Abhishek Kale, Deputy Managing Partner of this firm, which is a young emerging law firm having its offices in different places. So I now request Mr. Jaipat Singh Jain to please join us on the head table along with Mr. Amit Agarwal, Mr. Anil Kasturi, and Mr. Abhishek Kale. Welcome. So over to you, Mr. Jaipat Singh Jain, please.
Thank you, Lalitji, for that very nice, generous introduction. So we are all deal lawyers, and we discussed among ourselves that we should have a topic where we can share our experiences. Each of us has substantial experience doing deals. International deals, domestic deals, and therefore we are just as eager to learn from each other as we are to share our experiences. So we figured, let's have a topic where we'll be able to speak freely and in the process also give you a glimpse of the kind of issues we faced, and hopefully you will, as Lalitji said, avoid some of them. I practice law in New York City. It's been about 25 years. I've been a deal lawyer, and I continue to maintain strong relationships with India. and with my colleagues here. So I do understand a little bit of India law. I studied law here, but India law at that time and now has changed drastically. So I have to depend on these very smart people to do anything worthwhile here. With that said, I now would request each of you to take a minute and introduce yourself so that everybody else also gets to know us and we can more easily relate to each other. So with you at the end, go ahead and introduce yourself.
Thank you, Jepatji. Thank you, Lalitji. Good afternoon. I'm Anil Kasturi. I'm a senior partner in AZB and Partners. I've been working with the firm for the last 25 years. My area of specialization is corporate M&A, private equity, venture capital, corporate advisory, and private wealth practice.
Good afternoon, everyone. My name is Amit Agrawal. I'm the senior partner and head of corporate practice at SNG and Partners. I specialize in the financial services, M&A, capital markets, and distressed asset resolutions. Thank you.
My name is Abhishek Kale. I'm a partner in Nayak and Company. I'm in Nayak since almost 20 years. My core practice areas are M&A, and I also dabble in international arbitrations. Thank you.
So the topic, as Lalitji said, is lessons learned from deals that failed. Practice of law is practice. If I say that all my deals were fully successful, I might be lying or embellishing. If I want to say what percentage of my deals failed, I don't think I have a good answer. Because one of the fundamental questions which we grappled with among ourselves is, what is failure? What would you call a deal that has failed? Would you like to say something?
I think the obvious answer, Jepatji, is if the transaction is not consummated after being initiated, that is a failure. But I think in the context of M&A transactions, I would say that the connotations are far broader than that. We can have a transaction where the deal is signed, but one party walks away unhappy because the valuation is too high or too low, or the deal terms are not palatable to one party. The transaction is closed. One could say it's successful, but if one of the parties is not happy, then I would say that is one form of failure. The other form of failure could be where you enter into a joint venture, 2 years down the line, there is misalignment on funding, growth, there are cultural issues. Again, that I would say is a failure. On the flip side, there could be a transaction where after protracted negotiations, the parties find themselves in a situation where there is an immense gap in the expectations, and they decide that they should not proceed with the transaction. Rather than signing a deal, moving forward and starting the relationship on a disastrous note, I would say that is successful. The transaction has failed, but the outcome is successful. So to me, failure is anything which is not a win-win-win. And the third win is for the lawyers.
That's excellent. Those are some of the things we'll have to embellish here and there. Okay.
So in my view, as Anil also said, I subscribe to his view, but I think it's a very subjective question. Failure has to be seen from a prism, and it may give a very different contours. The deal failure could be a failure on the transaction table itself. A deal failure could be a deal where you have consummated the documentation, signed the documents, but in reality, while implementing the transaction, it doesn't become successful. It could be, the reasons could be various, which could be attributed to the failure, but I think you have to look at it from a prism and see why it has failed. Failure has different connotations. Even if you fail on a transaction table, it may be wiser to lose the deal there rather than giving effect to a joint venture or a project and then parties feel dissatisfied and move out from the transaction. So failure, in my personal view, has a very different connotation, and one has to look at it in a very subjective manner.
I did a little bit of a study, a little research, and I found that between signing and closing, there is only about 5% of deals. Some study had found between 1996 and 2018 that did not close. Which means that once the deal is signed, there might be many things. People may renegotiate price, people may structure the deal, do not buy everything, buy part of it, or renegotiate in any other respect. But they eventually ended up closing, and was 95%. That was what the statistics showed. My own experience is that I don't really have a deal which was signed and never closed. But does that mean that I would consider that deal a success? I'm not so sure. Like Amit and Anil mentioned, there is a bit of a gray area here. The fact that I got paid could be a good yardstick of saying, did it close and did it succeed? I would say yes, I have always been paid. But did the client win in the process to the criteria set by Anil? I'm not so sure. So that's my take on it. But I welcome it.
So for me, I would like to put it in three buckets broadly. One is a failure on account of when we identify certain risks for maybe regulatory, commercial risks, but unfortunately for whatever thing we try and mitigate it, but it doesn't go through. When we are talking about, the difference between an LOI and when we sign an LFA. Second bucket I would like to think is that unfortunately there are certain risks which we fail to identify as lawyers, which we do not specifically put a mind to, or commercially we are not aware of it, because it's not necessarily that it's only me and the company or the promoter or the investor. I mean, there are bankers, there are third parties. So certain things which we are not in control of, which we end up knowing very late at a belated stage, and we are not able to mitigate. And the third basket is, I will go a stretch further when a JV is inked, for example, and I am part as of the company, and unfortunately the JV doesn't go through. I think that is also, for me, is a failure, for whatever reasons.
Absolutely. No, I agree with that character. So as you can see, the topic seems very straightforward. It is easy to say the deals failed for XYZ reasons, but what exactly is failure is in of itself a subject of some discussion. Be that as it may, are there some lessons which we have learned? I don't mind how you characterize failure, but I'm curious to know, if we were to do a quick 1, 2, 3 kind of a response from you, would you be able to list 1 or 2 top things that came from your experience of why the deal failed?
There are many reasons. Some of them are obvious, some of them are not so obvious. One less talked about issue, and I think Lalitji also alluded to this just a couple of minutes ago, which is the ego dynamics of the advisors, which is at play. Very early on in my career, I learned that it is best not to get into a ego tussle with the counterparty's lawyers. Otherwise, it would just lead to risking the deal itself. As lawyers, we like to believe that our profession is an intellectual profession. We have a combination of intellect, experience, knowledge, and of course a lot of hard work as well. So there is gray matter at play when you're in negotiations or when you're in the court as well. And what that does is that when we are involved in negotiations, a large part of the negotiations is spent on essentially trying to counteract the opposite counsel's arguments and positions. And as a result, there is that ego which comes into play. because trying to impress your client, you're trying to impress the counterparty, and what that could result in is actually lawyers ending up taking very hard positions, pedantic positions, and sometimes the negotiations themselves become adversarial. And as a result, we miss the wood for the trees. Just to give you an example, there are transactions where you have a signing and then you have a closing and then there are CPs. When the parties know that the time gap between signing and closing is just 3 days, there is still a lot of time spent on negotiating material adverse change, as an example. Heavens are not going to fall in 3 days, right? But yet you want to prove a point, you belabor the point, you sort of exhaust everybody at the table simply by negotiating again and again. This sort of one-upmanship, I think, contributes sometimes to deal fatigue, and as a result, the deals themselves could fall apart. Of course, where there is a sophisticated client, they could come in and sort of save the day. But in a lot of transactions, especially in the startup context, the clients actually rely heavily on the advisors to make the right calls for them. When in very early days, I was actually working on a healthcare transaction for a client, and then there was an impasse on the deal. And the promoter called me and he said, Anil, I'm actually trying to build world-class hospitals. And here you are trying to prepare world-class agreements. There is a conflict. It was a very subtle message. It sort of stayed with me for a long time. I would say that I think, when you get into a negotiation, you should get in with the approach of being collaborative, constructive, try to understand what the other party is saying, where they are coming from, and that would hopefully lead to a business solution to a legal problem or a win-win sort of a mid-path solution, and that works for everyone.
So just to take further what Anil said, I think in my experience of negotiating transactions on a table, I come across few instances which have always remained stayed put in my mind and in heart also, that I will ensure that I will do certain things in a particular manner and certain things I will never do. Whenever you get into an M&A transaction or you're negotiating a time-bound capital markets funding transaction, the biggest challenge which I as a lawyer really face, and I'm sure this will be echoed by many of my fellow colleagues as well, is that there is always a thin boundary of difference between the role that we have carved out for ourselves and the role which the other advisors and the bankers have carved out for themselves. SEBI guidelines and the interpretation and how the past precedents have played out becomes a kind of, for a lack of a better word, a mud ground for people to really wrestle around. So there are advisors and bankers who will transgress the line and get into the legal domain and say that in the past particular transaction something has been done, why it can't be done in this particular transaction. While it had been done, but facts of those cases could be absolutely different, which they are not able to apply and appreciate. So that's one. And similarly, many a times I have seen lawyers, while it is very good that we need to be very practical, we need to understand how business has been run, we are still not being able to draw lines as to what is the area which has been carved out for us and what is the area which has been carved out for the banker or an advisor working on that transaction. So when I as a lawyer, instead of at the term sheet stage, really working on to the definitives, start getting into or start questioning the veracity of a deal or why a particular point has been agreed upon, which may have already been negotiated at the term sheet itself, I am just bringing a conflict on the table which could easily be avoided. And sometimes those conflicts could become so paramount that lead to the failure of the transaction. Another important issue whenever I'm sitting from a buy side or from an investor's perspective on a transaction table is that I see challenge coming in from the diligence exercises. There is always a gap between a cup and a lip. You can do diligence comprehensively, but there will be many things which you may still not be able to come across. There could be some challenges with regard to coordination among the lawyers with regard to having a look at a financial diligence report or looking at the operational diligence report or say the vendor diligence report, and you are not able to factor in what could be a legal risk which may come out and you don't factor that in. Now, those are the kind of challenges where sometimes the sell side really plays. So diligence outcomes becomes a very challenging point. Certain things which are not being told the way they should be explained, uh, you know, really plays a havoc. Forensic audit, certain things which are not being disclosed, but comes out specifically post execution, but prior to closing, becomes a challenge point. And sometimes what happens is both parties are very keen to take the transaction forward. So certain crucial things are being pushed from condition precedent to condition subsequent, and we all know many times those conditions are never been met out, and that lead to a very disastrous situation of failure of the transaction. Now that failure is a is post consummation of transaction out, but it's a failure. Another thing is, which I have seen largely, is there are people who, not for the interest of the transaction, but for their own self goal, sometimes try to push a transaction. I've seen largely again in the M&A sphere and the capital markets, the advisors push both the sell side as well as the person who's going to invest the money to do that particular transaction. So that conflict, which is a conflict of interest from my perspective, between a person and an institution, plays a havoc. At the end of the day, I as a lawyer will also like to earn fee for the time that I've spent. Fortunately enough, more than 80-85% of times, even if the transaction is a failure, we get paid. But fact of the matter is, if you get pushed to close a transaction in a particular manner with which you are not very comfortable with, also creates an issue where you ultimately see that this transaction, while may get executed, but will not see the light of the day.
I totally agree with you. I have had an experience, very frustrating experience, in which the investment banker compensation was to come from the buyer at the end of the deal. Common. So the investment banker and the client totally depended on the investment banker, to the point that where the client would not even read the papers and sign anything that the investment banker would hand him over. And I was aghast that my client would not spend time reading the documents and would rely on the investment banker, when I knew that the investment banker was pushing for the deal to close because compensation depended on it. And the funny thing is, the investment banker selected me as their counsel. So it created a stress level for me, because that added to my pressure as a counsel, because I kept explaining to him that I'm sorry, but you are not acting in the best interest of the client. He says, Jepaj, I'm the one who hired you. I said, but that doesn't change anything for me. I'm still counsel for the client. And this created, well, the deal closed, but I felt till the very last minute extremely uneasy, almost like I was trying to cover my back by writing long emails to the client, explaining that when you enter this, this is the risk, and you are still entering into it. I hope you understand. No response, but the deal papers were signed. So situation like which you have mentioned is a very real situation which we as counsel face, and it creates a tightrope for us, you know. Sometimes we simply take the stress of the client, assume all of that stress as if it is our stress, you know. We become more loyal than the king because the client is not paying attention to the papers. But yes, I agree with you, and I'll come back to this conflict of interest issue again, but let me turn to him.
Yeah, just to add on the point that the investment banker and the role they play, frankly, I think that happens especially when you're representing a promoter or a company, and the banker obviously is given the mandate to bring the funds. And I've had a candid conversation with one of the promoters stating that, you know, the contractual restrictions and the covenants are, you know, so unbelievable. I think we regret that. And I had to tell the promoter. The promoter had a very simple answer. Abhishek, I have been a guarantor, I have taken debt, etc., etc. So I think for me, comparatively, this is an easy way out. So there are perspectives depending upon where the client is and at what stage. I know one of the other aspects of the investment banker is he's obviously taking on the role of the lawyer for the client. He's doing everything, we're taking instructions. I think it's been happening for quite a while now that the client essentially speaks more of the commercials and we implement them. But I think more and more I see it because if you represent the company and the promoters who are a requirement of money, I think that happens quite a bit. Yeah, you want to say something?
So this is one, but I have also come across the situations where even if you are on a buy side, especially when you are looking at a fund and a fund is towards the closure of its life, even the fund manager or the people who are so-called the principals of the fund would like to close the deal because they want to deploy. They don't want to have an uncalled capital left and not deployed. I've seen situations where because of that paucity of a time, they also want to do that particular deal while you know that this is not good for the fund as a whole or the investors behind the fund. I've seen situation on both sides.
Yeah.
So I made a rule for myself that I'll like to share. And I'm sure all of us have similar rules for our own conduct. I try to avoid, not always successfully, three things. And I will call them the three F's of failure. One is I want to avoid a situation of deal fatigue. I have felt that for me, success is that when the deal concludes, I go out and rejoice that evening. Failure is that when the deal concludes, I say to hell with it, I'm glad this is over. So I don't want to be in that situation where deal fatigue sets in for the client, for myself, or for the other side. So that's one of my yardsticks of success of a deal. Try to avoid deal fatigue. Don't over lawyer. Not always successful. The second thing I try to worry is that at some point, costs of the deal become an issue. And if you want to lose a client and win a deal, it's a bad bargain to have. So you can decide what you want. You want to keep the client or you want to, close the deal only. So that is another challenge as a lawyer which I face. So I would say the second thing is the fees of the deal. Because unlike many here, we, at least in New York, try to avoid fixed fee businesses. And I am always happy to lose a transaction because this fixed fee business doesn't work. There is so much work we do behind the scenes as lawyers. Not all of it is billable. And if I open myself to situations with a very low number in order to land myself a deal, I'm really losing my time, which is the most valuable thing, to a cheap deal. And I know soon I'll get another deal which will be full freight. So I'm not so worried when I lose a deal. So another thing is fees. Keep in mind that if you're on full freight, your fees has to be reasonable. Otherwise, you'll again lose the client. And the third thing which you kind of flagged, I just have added the word F, but it is really ego. It is friction. Whether that friction arises between lawyers or between the clients on both sides. Is this a good characterization, or would you add a few more things to this list?
Thank you. No, I think the other often overlooked aspect is the regulatory processes involved in a transaction. Normally, parties, when they start discussing potential M&A or an acquisition, a lot of time is spent on your valuation, your deal terms, indemnities, and so on and so forth. But very little attention is given to the regulatory processes involved in getting the transaction to a closure, be it approval of a regulator or a filing. I mean, I've seen that parties sort of tend to push that right to the end and somehow sort of be comfortable with the fact that it's par for the course. Once we file the application, we'll get the approvals. So the whole deal is built up on the basis that the regulatory approval is sort of given. And we've had multiple situations where transactions have actually not gone ahead simply because either an approval took a very long time and the parties decided to move out of the transaction, or the applications themselves have got rejected. In one situation, I remember again 15, 20 years back, a publicly listed company was raising funding from an investor, from a foreign investor, and they had to get the FDI approval. Uh, the application was filed. There was a lot of last minute preparation work done by the lawyers from both sides. The application was pending with the government for almost 12 months. And by the time the approval came through, the stock price had risen considerably. And the seller was unwilling to sort of dilute unless there was an upliftment in the price. Now, the investor wanted to do the deal very grudgingly. He paid a higher price, got the deal consummated, but it was not a sort of a good outcome for them. The second situation involved a merger again of two very large companies. The transaction took almost 9 months to sign. Again, I think the whole regulatory process sort of kicked in at the last minute. We filed the application. After some 6 months of back and forth with the regulator, the application got rejected. The transaction had to be abandoned. In a slightly different situation, it was a change of control transaction, and we had the opportunity to actually engage with the regulator in advance of the signing itself. And the feedback that we got was that if it is a change of control, the approval ain't coming. And then we had to sort of rejig the deal. The transaction changed from a change of control transaction to a minority investment. We filed the application and we got the approval very quickly. I would say that, when we talk about preparation on the regulatory front, or what is preparation? It is basically try and engage with the regulators wherever possible. It's not possible in every situation, but wherever possible, try and engage with the regulators very early in the deal process. And second, of course, is keeping your ear to the ground to understand what has happened in similar transactions with the same regulator, whether the outcomes were positive, negative. There are a lot of learnings that one could take away. But having said that, I mean, the fact of the matter is you can't preempt this in every single situation. And especially in the Indian regulatory environment, there are a lot of surprises which get thrown up time and again. You don't even anticipate the sort of issues that come your way. But I would say that still, purely from my experience, the focus on preparing for regulatory approvals and processes right from the beginning would lead to no disappointment at a later point in time.
So let me just try to add one more F to the list. So after you have crossed the stage of friction and you've also come to the terms with the fatigue, sometimes what happens is the financing or the funding term changes of a transaction. It's like sometimes you get a sense of it when you look at a term sheet that there is something which has really been missing, and when you get onto the table you realize that. And after as Anil said, ego, I would say we have done the mud fight. We come to a particular term and then party steps out, comes back after an hour or so and say, guys, we have some new terms on the table. Then you feel like, oh, we all had it. So after you cross the friction, the fatigue had set in, and after that, when the financing term changes, that really creates a havoc on the deal, because now you have come to a stage where you don't want to do more on that particular transaction, and term changes, which requires you to have a relook with a very fresh mind onto the transaction, because the change in a percentage from 26 to 49 is something which we all understand in terms of an equity. What is going to be the shareholders' rights vis-a-vis someone who was holding 10% or now going towards the 90%? That the whole game changes. The understanding amongst the shareholders completely changes. The way you look at the reps warranty completely changes. So that's another area where I feel I've seen those kind of situations.
It can lead to a complete retrade. Yeah.
On Anil's point about the regulatory aspect, actually, how much of the preparatory thing which we do, frankly speaking, there is no real direct clarification we get from RBI. There are authorized dealers always in between. And frankly, how much have you try and prepare? It's not necessarily the best deal which we get. For example, we are doing a transaction and we know for the fact that this particular aspect, the lawyers are active. They are not on the same page. So we have filed for a clarificatory application, which is pending for last 6 months, whether an approval is required or no. So it's never easy to, prepare all the time. But at the same time, it's the way I look at it, we have done certain deals where we do preparation, it always helps. But there are always problems at the end of the day, the commercial changes. And that's where I was going to come to the role of the investment banker as well. Because I think I've seen lately for the past 6-7 years, even if you're for the acquirer or the other way around, I think the investment banker actually decides quite a lot of things for us. Uh, the way I have been seeing, the role not necessarily only depends on the valuation, but they discuss pretty much nowadays even the contractual provisions. So that becomes very tough as a lawyer to actually appreciate where the lines are drawn, something which we are coming to terms with. But somewhere down the line, I feel if that is the case, then we all should be on the same page when we are doing negotiations, when we are coming across other side lawyers and also the other side in terms of drawing in commercial term sheets broadly cover the aspects, but when we are doing the diligence and the outcome of it, when you're talking about the reps, warranties, and all the detailed clauses, even CPs for that matter. Now, whether it's we deliver a document in terms of having according to us as per our diligence, these are the CPs you should have. When internally people discuss and say, we don't want the CP. We do not necessarily have all those sort of things. So, yeah.
Another point you touched, and you also touched earlier about due diligence. Because in my experience, I have found, and I might be, my case might be unique, and I'm trying to generalize also. But I have found that when I am representing the sell side, I wish there was a discipline associated with seller due diligence. That means the seller goes through a pilot process of studying its own business and identifying the red flags rather than waiting for the buyer's counsel to do that and then doing a firefight. So in situations where I have found deals caving has been where the seller has been mostly in denial. And when something comes up, they respond by expressing anger. Oh, these guys are this, they are trying to do this, they are trying to do this. Well, I think the most difficult conversation for me has been when to tell your own client that I don't think that what the buyer's due diligence has flagged is a non-issue. It is a big issue. How is it that you don't have corporate records showing to whom shares have been issued, for example? And so this internal due diligence prior to the sale or just before the sale or at the stage of LOI, somehow in all the books that we read and all the CLEs that we took, this was never highlighted, that seller beware or seller do your own due diligence. But now I have begun to tell my clients that before the buyer sends you a due diligence list, I have a set of questions for you. Here is my due diligence checklist. And my client sometimes reacts viscerally. What do you mean, your due diligence checklist? I said, yes. Before I get a due diligence checklist from the buyer, I want these questions answered. Because I think you also highlighted in one of the things, both of you did actually, that one of the things that we find when we are in the midst of a deal is things that our own client had not disclosed to us. And the initial reaction that, oh no, the buyer is trying to retrade and the buyer is making a big deal out of nothing. And then you tell yourself, no, that's not the truth. The truth is that you didn't have your records right. The truth is you didn't document this transaction. The truth is you had a conflict of interest that you hid from us. And I think you pointed out, Amit, that you have consents to take which you didn't disclose. And I would like you to talk about it because I thought that was a very beautiful point, very real. The only time you will hear it would be in a sitting like this, because we need to be acknowledging these defects in how deals get done. And we chase the outcome, but we don't do the homework.
So I'll take a minute to create the background about what I'm going to speak on. So usually what happens is, unless you're doing an M&A in a large corporate transaction, if you go to a mid-market or a MSME segment and you're looking at an M&A happening over there, usually they would have some credit lines coming from banks and financial institutions. And most of the mid-tier corporate houses or MSME players may not have that negotiating ability to really sit across the table and negotiate a document. And sometimes they just accept the diktat which is coming from a bank or a financial institution to say whatever is being recorded, they'll just accept it. So I'll just give few examples that we usually come across and becomes a very challenging point. So sometimes something which is talking about if there is going to be dilution of an equity stake below a particular number, beyond a particular number, that becomes a challenge point. If you're going to change a capital structure, now capital structure can change for various reasons, including increase in a capital is also kind of a change in a capital structure. So clauses like that also leads to a approval situation. Then apart from that, there could be a scenario where your indebtedness is going beyond a particular threshold. Again, they will just accept it and move on because they want to win that battle. They don't wait for the war situation to come in. Now, if you get into an M&A transaction, and let me just first touch base upon the point with which you started. I think today, at least in the Indian corporate world, people are now becoming aware of the fact that before we get into the M&A, we must do a bit of a reverse diligence on our own self. I think the corporate houses are now being well conversant and recognizing that particular aspect, but it's not still the nature or in vogue as such. So if you get into a deal where you have not prepared the data room or not have looked at those things, that have not already been briefed about particular issues which could be put to you by the opposite side. So what happens is when you negotiate on a transaction, your every line of argument is based on a particular aspect, and then you build the story around it. And then sometimes what happens is the other person just pulls it out something and places it onto the table, and your whole line of argument goes for a toss. So that's very relevant from a perspective that why reverse diligence on your own client becomes very, very important. And also from the approval side, if you've not created the data room or you've not done the kind of a reverse diligence, you will not come across the situations where the other party is going to seek consent from those lenders, financial institution, or third parties with whom certain important contracts the company to whom you are representing has entered into. And then you are dumbstruck because they pull out and they said, this is a particular contract, we have seen this particular situation, this is the clause, and you are not being aware. So those are very, very challenging aspects from the company's perspective and also from the lawyer's perspective. And this lead to the ego issue which you highlighted, because when you lose a point, you have to still cover the track for your client. You're not doing it for your own self, you're doing it for your client. And then the whole F story starts.
I just like to add to this point on due diligence. I think what you said is absolutely important, which is to sort of clean up your act before the investor comes in through your own internal diligence. The good thing is we are seeing a lot of that now in the Indian context. A lot of the startups which don't have time to sort of focus their attention and make investments on regulatory processes, before they go to fundraising, maybe in Series 2, Series 3, they would like to get their act together. They're inviting firms to come and do a vendor DD, clean up, and then present a report to the investor. The other slightly nuanced aspect here is, again, going back to my earlier point about being cooperative, constructive, collaborative. Even if there is no legal diligence done by the seller or the company, I think we also owe it to ourselves as advisors to a buyer or an investor that if we are doing a diligence on the company, the easiest way to address issues is to say, let's put it in the rep and warranty bucket and take indemnities and so on and so forth. But I think what would be more constructive and important for the client would be to actually engage with the target and help them actually clean up whatever you can before the investment comes in. And a lot of counterparties actually saw a lot of value in sort of this approach, where you tell the target that, listen, I mean, we are here to help you. We are not here coming in like some, auditors in black suits. We are here to help you. If there are some issues which can be resolved, filings that have to be made, if they don't have the bandwidth or the expertise, we are sort of there to help them with the process, so that at least by the time the investment is made, not 100%, but at least 50% of the legal issues would have got resolved through that process.
Yeah. So one more point with regard to startups and diligence. I think I had been fortunate to actually be representing a few of the angel investors in these startups. And one of the things as the advisors, we ensure that the company which startup which we believe we would like to see grow up as a unicorn, etc. But fact of the matter is, unless and until you have corporate governance and all these sort of things, you will not be inviting, the soft capital and all that sort of stuff. With venture capital guys, all these guys will be doing diligence. So one of the things which we ingrain as a starting point is, yes, we would encourage you, will provide you time-to-time investment, provided that there is a corporate governance, there is a secretarial aspects and all that sort of stuff. So one of the things we put it as a CP for all the time is that, whatever the startups are, they should have a law firm purely into a compliance base, and we have to do the quarterly compliance thing running around. So, over a period of time, if it gets successful, I think the culture is absolutely there now, unlike what it was earlier.
Often you get hired by a seller uh, who you have not previously represented. You get hired at that 11th hour, often after they have done their LOI. And they have done that term sheet, and they are now shopping around for a law firm, and they found your name somewhere, so here you are. Or somebody calls me because he has dealt with me, he knows me, and says, "Humko ye deal karna hai," or something like that. But so there you never get a chance to sort of help the client. It's not like your existing client who's going and doing a sale transaction. It is you just got hired fresh. But since you mentioned these angel investors, I want to ask you, there's one other thing which you also mentioned is that when we do the deal, it's not just one deal in an M&A transaction. It is really 2-3 deals taking place at the same time. If you are representing a private equity buyer, then or an investor in a company, you are really not doing one deal. You are also constantly keeping in mind that there is a financing deal to be negotiated. So even though you may know all the bad things, you may not actually tell it to your financing source. You may withhold it from it. So that creates another stress point for us as lawyers. How much to disclose and how much not to disclose. There's a duty to be candid. There's a duty to be honest. There's a duty of loyalty as well. So you have a very tight rope to walk, and you kind of work with the financing lawyer in a bit of a stressful period of time. You don't want to lose the financing, or your client telling, what the hell did you do? And because you are the point through which that financing deal is consummated. So there is another stress point for lawyers, and a very great likelihood that the deal might get renegotiated, might fail, might collapse. And then there are circumstances where there is so much compulsion to invest, because you have to show your fund having invested into some businesses. So there is this push, damn it, why do you keep raising these issues? Close it. And then you have again these questions. So I tried yesterday night to make a list of what are the things as a lawyer, and you can supplement it, I want you to supplement it. What are the things expected of a deal lawyer? And I tried to make it into a bit of a moniker or something easy to remember. And I'm not sure it is easy to remember, but I'll try. ANDE. A, that you come to your lawyer for advice. Now, these are like 4 legs of a table. If one of the legs is not there, the deal becomes shaky. So the first one is clients should seek advice from their counsel. And they should consider him a business person who also knows law. When I was a kid here, Steel Authority used to run a ad. We also, I don't know if it still does, we also make steel. Would you remember that? So Steel Authority used to run a very wonderful ad on television. At that time, there was only Doordarshan. And at the end of it, it would say, we also make steel. And they would show how they have transformed towns where they have created steel plants. It was a very powerful ad. And so we are lawyers who also do law, but we are basically business advisors. We are wealth creators. And the businessman should understand that. But sometimes they don't listen to you. They listen to the investment bankers or the KPMGs of the world. Uh, and so that's one leg. The second leg is we document, we do paper, we are paper masters, we are wordsmiths. And then we negotiate. So that's the third leg. And the fourth leg is we engineer the process, how this thing should get done. So we do four things, A and D, E. And anytime a client shortchanges you on one of those, doesn't seek advice, doesn't expect you to engineer the process, wants to engineer it remotely themselves, I think there the deal or the table becomes shaky. That's what I concluded. Is that a good assessment, or would you like to add something to this?
No, absolutely. I completely agree with that. I mean, we've seen this many times where you have the client engage with investment bankers. We've talked about this at great lengths. And then the documents come to you or the term sheet comes to you already sort of agreed and signed between the parties, and then you're requested to prepare definitive agreements by yesterday. And I actually had to tell a banker that, agreements are not vada pav. It was a Mumbai-based banker, so I thought he'll understand that language. I mean, we need some time. And there were a lot of other issues which sort of got flushed out through that process of drafting the agreements, which the bankers didn't think of, nor did the client. And then I could see that there was a lot of irritation, because when you start flagging those issues and say, have you thought about this? They're like, no, let's move ahead. This, we've already sort of agreed to things and now we need to get the deal done. I think it's very dangerous. I mean, I'm happy to have a deal sort of fall apart and not be there in the, the deal list, but not compromise the client's interest just for the sake of getting a deal done. That's not our role. And Jaipaji, I think you very nicely said that we have to think from a business standpoint. I actually believe that as lawyers, as commercial lawyers, for every legal problem, we have to think of business solutions, not legal solutions.
I just want to supplement that by saying that many a times I've seen on a transaction table, lawyers sometimes don't come prepared in terms of understanding the business. When you're doing an M&A or you're doing a funding transaction, either ways, whether it's a debt or an equity, you need to understand what the business is all about. What is the intricacy of the business? If the receivables are getting generated, how the cash flow is being managed, how the vendors are being managed, what is the distribution channel, what is the channel financing for it. Unless you understand the nitty-gritty of a transaction, you will never be able to negotiate the transaction for the benefit of your client or for the benefit of the transaction. I think my biggest challenge when I come across is when I negotiate a transaction, especially on the representation and warranties, after a particular point, the other party tells me these are boilerplate clauses. I fail to understand that how it is a boilerplate clause vis-a-vis a particular business. So that, in my view, is an aspect where there's a lot of learning for us as lawyers also, that when you get onto a table, sometimes, yes, as Anil said, we come to a situation where the term sheet has already been signed. We can't pragmatically add value to it. But the question is, could we still get a couple of hours to negotiate or to talk to our client to understand what the business is all about before we get onto the table? That becomes very crucial from my perspective. Thank you.
Jalpaji, I agree with the pillars or whatever the four so-called legs are concerned, but I think there is one more aspect nowadays. What's happening is whether you are representing the company or representing the investment banker. I think a GC becomes a very, very important part nowadays, the way I look at it. The role has increased quite a bit, and I think they, unlike the earlier part of at least my professional life, where we used to directly deal only with the principals as far as any venture capital fund is concerned, or a company where you're directly dealing with a promoter. But now a GC plays an important role in both aspects, the way I look at it, to bridge and try and make a situation plausible. That's what, at least for the past couple of transactions or other, maybe the past 3-4 years, a GC, at least in my clientele, I've seen they play a very important role to provide solutions and mitigate those aspects. I understand at the end of the day, if you're for the company, you would be desperate for the funds. So you do not want to get into these so-called issues. But as an investor, at the end of the day, there are two aspects. If it's a fund, they would like to quickly deploy their funds and move on with life. But at the same time, there are certain things which we say, which we talk about, very, very important to actually bridge those gaps. And I think a GC plays a very important role. Yeah.
We may have run out of time here. Do we have time to take one or two questions? Or?
Yeah,
Okay.
mine
So-
will be the first question.
Yes, sir. Please.
Not a question actually, it is an observation. Because when you talk of a deal, are you talking of a concluded deal or you are talking a deal in the making? Because there will be two different consequences for failure. First is that deal is not concluded. That means the parties have not been able to come to certain agreed terms. In that, the lawyers have a very, very limited role because these are all policy, business decisions which are to be taken by the parties to the deal. Other situation is that deal fails after it has been accomplished, you see, completed. Now that again may be due to various factors. Over-regulated, you see, the regulations are there, compliances are there, you are not able to fulfill, you see, the requirements of law or regulations, and possibly the profitability or feasibility is no longer possible. There again, the lawyer's role is again limited. Firstly, because when we are talking of why deals have failed, we are talking of multi-million deals and all those things. There are general counsel also who are there, who advise, you see, their respective employers. Then role of external lawyers come. So it is if we are attributing anything to the external lawyers, the professionals, it can only be due to either some wrong advice given or some negligence on their part. So I just wanted some observations on these.
Both very, very good. This was actually the threshold issue which we probably gave short shrift to. We could have probably spent a little longer time on this definitional threshold issue as to what do we call failure. Is it that the deal didn't close or that the deal did close but it failed? It resulted in litigation, for instance, and it resulted in litigation soon after the deal closed. In fact, there are circumstances which I have read about, but I didn't have that situation, so I can't pretend to know too much. But we read in our experiences and we read in newspapers that the deal closed and the next day there is a litigation. That means that the parties knew, and it takes us to the sandbagging or anti-sandbagging issues. But you are absolutely right. If you permit, we can have another 45 minutes here. Any other question? Yes, sir.
Thank you. Sir, I'm Himanshu Singh Sagar, advocate, Delhi High Court. So it is not a question that I want to ask, but it is just an input that I wish to make to Mr. Agarwal. As you said, sir, that you have seen that lawyers are not prepared. I must say that is not true. One of the reasons why advocates are known as learned counsels because they are learned. They're always prepared. It is so that the clients, they do not know as to what all details do they need to share with us. And that is one of the reasons why they feel that the lawyers are not prepared. We are learned because when we make a cross-examination to a doctor, we should know more than him. When we do it to an engineer, we need to know more than him. To an IS, we need to know more than him. So please don't put this, that we are not prepared, sir. Thank you.
Your point is well taken, but I'm coming more from a perspective of building a transaction. So when as a transaction counsel, I go onto a table, I may not have a background about a particular business
Okay.
or the intricacies associated with it. That's how the point was started by Anil when the term sheet is being signed and we just put onto the table. So when you do an M&A transaction or when you do a cap market transaction, you have to understand how the business is being run.
True.
And each and every aspect of the business which could lead to filtering out of the money or adding to the cost
Correct.
could lead to growth or depreciation of the business, which lead to coming out of the risk factors. So how to deal with those risk factors is the knowledge, which
This
we-
knowledge has to be imparted by the client.
Sorry?
This knowledge has to be imparted by the client.
Yeah,
Offline-
but the question,
I think we will, this is about practice of law. You are all practitioners. So I know we can engage and you have a very good point.
Thank you so much.
And,
Much obliged.
but I think we have to be mindful of the next panel. People smarter than us are about to grace this place, so let's leave them the opportunity to express themselves. Thank you. Thank you all.
It was a wonderful session. And as I said, it was unique that how and why the deals fail. So an analysis of that, the pros and cons, how deals should be made so that they don't fail. But sometimes they do fail, not for reasons attributable to lawyers, but due to some basic differences and all that. I think it was a very illuminating session. So a big hand you see to the worthy panelists, led by Mr. Jaipat Singh Jain, who has flown in specially from New York, you see, to attend this event. And now we'll have a brief memento presentation.
Mr. Amit Agarwal.
Mr. Anil Kasturi. Mr. Abhishek Kale.
Next session is on IPR. We will be starting now.
Next session, please remain seated. We have the session on intellectual property rights. Mr. Praveen Anand will be chairing this very important session. Yes, he's here. Mr. Praveen Anand will be chairing this session. He's the chairman of Anand Anand, but more than that, he is one of the most distinguished lawyers in the field of intellectual property rights, not only in India, but known all over. It's good to have you, Mr. Anand, to chair this very important session. And we have also Dr. Deepa Tikku of famous law firm of K&S Partners, who are intellectual property attorneys. And last but not the least, Ms. Madhu Chaudhary Gadodia, Deputy Managing Partner, Naik and Company, one of the emerging and one of the best law firms led by a very dynamic chairperson, Mr. Amit Nayak. So it's over to you, Praveen ji. Please be seated. Anyone who is outside, please ask them to come inside, those who are interested.
I'm trying to inquire from my colleagues whether this is afternoon or evening. Literally, you lose track of time when you're in court. I've just rushed from court. I'm sorry, my dress is all what they used to call pachranga, multiple colors. Please excuse me for that. Okay. So we've got 1 hour. That's a long time. We would like to talk about copyrights. Madhu will like to talk about some copyright issues. And Deepa will talk about some patent issues. And mine will be pretty much a hodgepodge today with certain themes which I believe might show Indian courts and Indian IP in very good light. That'll be the focus of what I speak today. So I think let me start by first introducing Deepa. Deepa has been with KNS Partners and has been a senior partner of the firm's management committee. And I don't like to read long CVs, so I'm just going to say she is extremely well known in our field. Deepa, you will help me by giving some 2 or 3 lines about yourself when you start. And then let me introduce Madhu. Madhu, to start with, is in Bombay. She does a lot of entertainment law work and acts for big celebrity actors and actresses. And also happens to be my partner in a law firm, Anand & Naik. And I must tell you that if you ever visit Bombay, you must see her, because her level of luxury and entertainment is, you will compare it to what they do with you in Lahore, in Pakistan. You may have all heard about that, how they just completely embarrass you because you think to yourself, if they come to India, I won't be able to reciprocate this level. That's what she does. She's amazing as a great, great host. So let's start with Deepa. Before I do that, just 1 or 2 points that I'd like to make. I just want to say that Delhi High Court, and of course, Bombay, Chennai, and Calcutta, but Delhi primarily, has turned out to be an excellent intellectual property jurisdiction. And over the years, we've seen it's almost like it's become a little bit of an ecosystem which is protecting innovation in a big way. You can pretty much do a test and ask, what is the great order passed today? What is the great order passed yesterday? What is the great order passed on the last working day? It's literally like that, because almost every day, fantastic judgments are coming from the court, which are putting us on the world map. So much so that one of the most prestigious publications in the last 3 months took a view that India is coming up to be one of the most sought after destinations for dispute resolution and in the world. And this was in the context of patents, standard essential patents. And that was the IAM magazine. And I believe the issue was probably September or October last year. And I must know, I'm sorry, it was this year, just 2 or 3 months back. And just a couple of things on dispute resolution. You may have heard of the kind of changes that have come about due to the Commercial Courts Act and due to the High Court rules, which have compressed the lifeline of litigation from 5 to 10 years to 1 to 2 years. Litigation really proceeds very rapidly forward. The kind of remedies that are granted are so unusual. We used to hear about Anton Pillar orders at one time. Now we don't talk about them. We talk about anti-suit injunctions, and we talk about pro tem orders, and we talk about all sorts of other roving orders, which are very progressive, and so much so that the reliefs have gone to extend beyond the CPC. For example, the Delhi High Court passed the tree order, where the defendants were made to plant 140,000 trees in the ridge area of Delhi, and the benefit of that would go to the plaintiff, the CSR benefit, and the public, of course, gained. So it was a win-win-win. And those kind of unusual orders are many, almost 20, 30 such orders. The defendant to donate books to the Delhi High Court Library, to donate dark glasses to the Blind Institute because they were pirating Ray-Ban glasses, or to spend time in a old home or in an orphanage, 30 days community service, and reports of them to come to court. So those kind of unusual reliefs. So very rapid disposal, unusual reliefs, and the concept of damages increasing more and more. So there was a time before 2005 when damages were unheard of in IP. But now not only are damages granted, but compensatory damages, even aggravated damages, sometimes running into lakhs of rupees, sometimes into crores of rupees. And damages are also collected. There was a time when collections were as low as 10%. Now they can be as high as 50, 60%. So in all, the atmosphere is a fantastic one. Recently, one of our judges, Justice Pratibha Singh, she came up with a new concept in dispute resolution, which is after the pandemic, the piracy of domain names had increased hugely. So what she did was she clubbed about 50 cases, and she started to get all possible parties that were involved with the registration of domain names, with the financing relating to opening of websites, and banks, ICANN, every possible interest, right from MIT to DOT. All of them were called to the court and asked for solutions on how the high levels of piracy in the digital world can be curtailed and can be controlled. And that exercise led to a lot of aberrations, a lot of loopholes, a lot of gaps were found in the law, in the practices, in procedures, and by her orders, she started to stitch them up one by one. And this was a very unique way of progressing rather than in the, we know of litigation, which is one versus one, A versus B, or we know of mediation, where you go before a mediator, or pre-grant litigation mediation, a pre-litigation mediation. Before you file the lawsuit, you go before a mediator. Those were early forms of dispute resolution. Now, the latest is bunching so many defendants together. So she's done that in another matter relating to rare diseases. So there are drugs which are given to infants who suffer from rare diseases. And those drugs have to be given lifetime, and they are extremely expensive. So 1 year's cost of that drug would probably cost $1 million, $5 million, money of that kind. So parents naturally can't afford that. So she discovered a way of getting money together. So the government was involved, various other organizations were involved, hospitals were involved, and the government was directed to put into a separate fund per child who suffers from that rare disease, and how the companies that are making those drugs for those diseases, for specified diseases, were asked to negotiate with the government a good price. And wherever import taxes were there, customs duties were there, they were asked, she directed the government to suspend those. So it turned out to be a great exercise to provide drugs to children who were literally dying. And these are the kind of rare dispute resolution measures which are being taken. In one matter, the court decided that the case must be decided within 1 week. So rather than accepting evidence before a local commissioner, the evidence was led in court, like the good old days. And it was live transcription was used to expedite the recording process. And in 2 days' time, the court finished the evidence recordal of all the witnesses, and the matter went to final hearing. So these are all the new measures which are being taken on the level of dispute resolution. There's a lot more to be said on on the substantive law, but before that, I will ask Ms. Tikku to tell us first about what are the kind of legislative and other policy-related issues which have come up, and the changes, to concentrate on the changes that have recently come up.
Thank you, Mr. Anand. Hi, everyone. I'm Dr. Deepa Tikku. I'm a partner at KNS Partners. I've been a patent attorney for last 20 years. Prior to that, I was a researcher, and I also worked in the industry. So from what Mr. Anand just gave us a picture, is that India has made a lot of strides in the area of IP, particularly patents and all different kinds of IP. When I was a researcher back then, and I filed my own patent applications before entering this field, it was so difficult for me to get a patent in India on my own, inventions. I could get a patent easily in the US and Europe, and I had those. But in India, I could only file for process patents. That was when the law was still old. And now, from there to this, I think there's a huge progress, huge journey that we have made as a country, as a nation. And there is no one factor which has led to it. I think there are multiple factors contributing. And what Mr. Anand just said, I think the judiciary has played an excellent role, and they are pioneering this whole journey as well. Now, what we are seeing overall in the patent space is, well, patents is a complex domain because it's obviously a monopoly which is granted to companies, and it's a negative right and all of that, especially in areas such as pharma, healthcare, and all of those spaces. It becomes a very touchy issue as well. In the public, reactions and responses to some of these issues are also sometimes maybe stemmed out of their own experiences, or maybe because of the rhetoric that goes around, and so on. So we have a long list of exceptions in the Patents Act, which actually create a barrier for patenting a lot of stuff in India, particularly in the healthcare space, in the agriculture space, and softwares, where, of course, India is doing great job there. So those are the barriers which are there. We've had our law change in 2005. That was the last time we had the amendments to the Act. Over the years, what's happened is that Indian, native companies, local companies, homebred companies are also investing a lot in the innovation space. So what's happening is that if you want to become an innovation leader, and compete with the major economies of the other world, of the West, and other major countries. Now, these are some issues which face you as well as a homegrown company. Earlier, it was a lot of defensive issues as well. We were a very defensive nation in terms of giving monopolies to outsiders and so on and so forth. But we've seen a lot of transition happening. We're committing, the latest union budget had, announced a long-term financial commitment of about 1,000 crore plus corpus in the area of R&D for pharma, healthcare, and so on, especially on rare diseases, on stem cell therapy, and all the latest technologies that may come up, medical diagnostics, and so on. So it is an indication that the government has been working very, effortlessly on actually, designing an ecosystem where innovation is recognized, it is respected, and that will help the patent ecosystem to flourish. Now, a lot of policy initiatives by the government have been set up in the recent past. You must have heard about Atal Innovation Initiative. We also have a national innovation policy in place. It details all kinds of sectors, including technology innovation and healthcare innovation and so on. We also have now the 5th National Science, Technology and Innovation Policy in place, and it was announced in 2023 with a huge kind of impetus to R&D and all kinds of innovation happening in the industry. Also talking about becoming an innovation hub by 2030, for example, for biotech, a 5 trillion economy getting there. The numbers that the government is projecting are enormous. But how will we achieve all of that if the patent innovation system, the patent enforcement system, or the patent, including the filing and the prosecution system, is not that great? Why would an applicant come to India and file their patents? And then if their patent are not respected, they're not enforced well, it becomes a counterproductive issue. So that's where all these organs of the ecosystem are trying to work very hard. Some of these initiatives have also led to, and we've seen that, initiatives like the startup policy and startup incentivization, also a very open-minded approach of the government to look at some legislative changes as well, reform in the legislations as well, or also kind of giving a confidence to the stakeholders, and the United States being the biggest stakeholder in India for patent filings. I think they constitute about, let's say, about total foreign filings, I think about 20 to 30% of the overall patent filings in India would be towards the US filings. So some of those topics are getting discussed very openly. The government is very open to discuss those. They have taken stakeholder inputs for reform of some of those areas of contention. And all of that is leading to an upsurge in the patent filings. It's visible. And we've seen even the homegrown company, the domestic sector filings increase to about 44% from what we would say about 15% maybe earlier. Now it's about 44%. And some of those companies are also filing abroad because they're taking their inventions abroad. They're looking for collaborations. They're filing, looking for markets abroad. So all of this is together creating a good environment in that sense. On the, the 26th of January, our Prime Minister announced that we've granted about 75,000 patents alone in this year. I mean, that's no no less feat. I mean, we've never heard that happen before. All of us in the patent firms or the law firms, we are actually also under tremendous pressure because of some of that. But yes, that is an initiative, that's a campaign almost the government is running. I think many of those things, and I'll talk about the legislative bit in a bit, but I just wanted to give an overview of what's happening in this space and maybe later touch upon some of
I
those
want
again.
to stop you here to talk a little about patent filing. Now, in the relative terms, it said we are the 7th largest filer in the world. In absolute terms, our filing is about 90,000 last year, as compared to 1.2, 3, I don't know, it's definitely more than 1 million in China. 1.2 or 1.3 million applications in China. A lot of people say that the quality of the Chinese applications are not so good, that they are low-level inventions which they filed. That's why their numbers are very large. Although a lot of people also argue on the opposite side and say that quality in this field trumps quantity trumps quality, because quality can only be tested 10 years after filing when there's litigation, or when there's a revocation, or when there's an opposition. Maybe not 10 years, 6 years, 7 years. But for the first 5 or 6 years, the numbers matter a lot, because when somebody has to invest in a country, they look at China, they see the number of applications, and they feel from the numbers that this must be a very strong patent protection country. And they can trust, therefore, their technologies in a country that has large filing. So numbers make a lot of difference. These are two opposite arguments. Is quality more important? Is quantity more important? In any case, what can we do to our 90,000 to push it to something like Europe, which is some 2 point something lakh applications. So which means really double this. How can we do that? So countries like Philippines have had their president say in public announcements that every company should attempt to file 1 patent every year. And that suddenly shot up the patent filing. In countries like China, the central body gives a dictate to every state or province that they must file a minimum number of patent applications. We haven't done anything of that kind by way of forcing people to file. That would probably be against our democratic principles. But we've used financial measures like incentives, lowering of fees for women and smaller organizations and for individuals and things like that. And of course, awareness and education. But is there anything you could say on this aspect of numbers?
Thank you. Absolutely, I agree, Mr. Anand. And in fact, India is producing a lot of science every year. That's a fact. And if you see the publications that our scientists are making in magazines or journals like Nature and Science, and to compare and correlate that with the numbers that we see is not comparable. We are doing good science. Firstly, the awareness issues were abysmally low. And of course, in the last 5 or 6 years, they've come to a speed. As far as numbers are concerned, we are growing. We've grown to a certain level. We've crossed about 65,000 applications, I think, last year from whatever data we had present publicly. Before that, it was something around 40, 50, and now we are at in the 60,000s somewhere. The China model, in the utility model system that they follow, they are also for incremental innovation, the smaller innovations. They have the law which can allow them to get patents on some of that. In India, we've tried, including in the, in the IP policy, national IP policy was getting framed. Something like utility models was proposed, but it was not finalized, so it didn't see the light of the day. Some of those things definitely dampen the as prospects for getting patents for smaller inventions. Having said that, I think, and also that also reflects our rank in the Global Innovation Index. Unfortunately or fortunately, if you have a good high volumes of numbers of patent filings, your ranking will go high. It doesn't matter if you're actually doing innovation or not, but if your numbers are high. But I think the law needs to be reformed in that sense, that if they allow incremental innovations, smaller inventions, then the numbers could see an upsurge, I think.
Let me ask you, Madhu. We could start with some of the smaller topics, but eventually we will go down to AI and copyright, and what kind of issues are arising there. Some people say that we've had too much of AI. Almost every session, almost every seminar, articles, books, there's so much of it. So I'm not going to kill everybody with more AI. But at least in a few thoughts, if we could have from you on AI and copyright. And one topic which I think it's been kind of overrated and is authorship in an AI work. Because at the end of the day, whether the author is the machine or whether the author is the person who caused the machine with his prompts to create a certain work, how does it matter? You have a work which is good, which is original, which needs to be protected. So if it matters, and I'm not seeing the point, do tell me.
Right. Thank you, sir. And I think, as you rightly said, it is inevitable to talk about AI in today's time for any topic. It's completely sector agnostic. Coming to copyright, recently we have seen a lot of issues and concerns, particularly after the AI. Some of them have not been very good, some of them have been appreciable. Like, for example, we all know that there was a lot of UN cry when the deep fake of Rashmika Mandana was popular. And at that point of time, the concern was that how does one protect and to what extent it could damage, considering a woman's face being morphed on somebody else. It's become so easy with AI. There is pornography, which is, readily being made available with this. And one of the cases that we did, and we had Mr. Anand only represent us, he got a fantastic order when we represented Mr. Anil Kapoor for his personality rights being abused through AI. So it has become very easy, and the real question is to what extent we can seek protection and how do we seek protection of this. The other aspect on this AI, as Sir rightly said, is, sometimes it becomes difficult to determine who's the infringer, who's the creator. In cases where, seeing the good part of it, there are works which are developed using AI very positively, and there are multiple questions which arise on authorship. For example, the data which has gone in training the AI module, which is actually owned by somebody genuinely, or which is owned by a set of people or multiple people, how do they protect or prevent or claim infringement of their AI, which they could have done if it was any other usage? Like if somebody's novel is picked up and reproduced in any other work, you can simply sue for copyright infringement. But if that novel is used for training an AI module, how does that how does that author claim protection of his work or claim authorship in relation to the work? Because there'll be no way to even determine what has got in the training process. The other is that the work which has got generated, again, as you rightly said, because there's a lot of mind which has gone, which has been applied to, kind of create the algorithm and then for the reproduction of the work. We certainly cannot have the machine claim the authorship of the work, so it'll have to be the person or the mind behind it. So to what extent can we register such works? All these are currently gray areas, and over a period of time as things develop, we will certainly be able to see the light of the day. AI has also been used in a very nice and beneficial way by many people. Like, for example, if you have seen the recent ad of Zomato, where you see Ranveer Singh, one of the most popular actors, place an order on Zomato. That was one ad which was shot and it was replicated for almost 1,000 times. Now, it was not possible for him to do it 1,000 times or to spare so much time to do it over and over again. It was not possible for the brand to pay him so much to do it. So AI helped in replicating the content, which was done with permission, and it's an authorized form of AI. Similarly, you see many singers, the singers which are of the current times, or sometimes even the deceased singer's voice being replicated to reproduce songs. Now, again, some of it is authorized, which is very good, very positive, because it increases the reach, it increases the avenues for monetization. But when it is abused, like for example, if a deceased singer, let's say Kishore Kumar's voice, today you have an app which enables you to listen a song in Kishore Kumar's voice. What rights are being violated? Who can claim protection for abuse of this right? Because even after the death of personality, the question is whether the rights vest in the legal heirs or no. That again is a gray area because we have different courts express different views. Like the Delhi High Court is of the view that the rights do not survive after the death of a person. So in this situation, using AI, it is very easy to develop, to replicate things. But to what extent you can protect, who can seek protection of that is certainly a question mark. Also, another important aspect is the NFT. Now we have seen in today's world, there is a lot of, because this is digital asset. And today, whether it's a painting, whether it's it's an image, whether it's a work, the real monetization can happen if you're successfully able to create an NFT and exploit it on digital platforms. Now, again, when you create the NFT, to what extent is it permissible for, let's say if there is a brand, or let's say if there's a producer who's got the rights of a particular character to create NFT, use the images of the personality over and over again to own it, exploit it, and then keep the revenues. So all these are aspects which are, currently in live issues as far as the digital world is concerned. There are other jurisdictions are already, being very aggressive on this, and they are coming up with various digital acts to address these issues, to clarify as much as possible. Even our Ministry of Information and IT has issued some advisories between last year and now, and they are trying to come up with clarity on these issues more and more. As Sir pointed out, the Anton Pillar orders or the John Doe kind of orders where, you cannot keep on every time knocking the door of the court, especially when you have repeated recurring infringement, when you have time and again unknown infringers. At that point of time, the John Doe order comes to your aid. This is not like a gag order, but it is certainly an order which comes to the aid of a plaintiff to prevent unauthorized exploitation?
Okay, let me change the scenario a bit. When the internet came on into our life, 90s, I guess, mid 90s, we were at that time struggling with very basic questions like whether a domain name would be capable of trademark protection. And I remember the first case, Yahoo case, where it was argued at great length. And what was done, the judge didn't understand what the internet was. So what we did was we told him, during the lunchtime, we'll set it up in your chamber. He couldn't believe that, something could be brought and set up in his chamber. But we did that. And then after that, he had recently given a decision, and we went and took him there. And we, in Alta Vista, which was a search engine at that time, we put his own decision there, and it popped up. And he was so fascinated by that he started reading his own decision. He read a couple of paragraphs, was quite satisfied and happy, asked for many books on the internet, and gave an absolutely fantastic decision in the Yahoo case, which you must read about, Yahoo versus Akash Arora. From that time, we had cases on meta tagging, hyperlinking, framing, phishing. All these different torts came up, and the law started to develop. But essentially, if you looked right at the root, you found it was an old tort which was given a new flavor. And so if the judge knew the basic elements of the old tort, he could extend that quite easily. And so we were successful in all those torts. Now we've got a new range of them. Dark patterns is one. Second, sorry? Okay. Also, after dark patterns, doxing. Recently, there's a decision of the Delhi High Court called Unnamed versus Squint Neon, which is on doxing. Doxing is public embarrassment. So you unmask the anonymous information about somebody publicly. And so that's called doxing. And there's catfishing, using someone's identity to create your own. Or there's gaslighting, to psychologically manipulate somebody so that the person loses his confidence. Or salami slicing. Salami slicing is to steal small amounts from somebody, which then becomes a bigger amount. Or confirm shaming. Confirm shaming is to make somebody sign a declaration where he says, I don't believe in equality. So he gets embarrassed, doesn't want to sign, and you end up achieving some objective. So these are the kind of new torts which are now coming up. And the next couple of years, we will have cases. We've already got cases now on doxing. We've had cases on in the Aradhya Bachchan on deep fakes and fakes, where an injunction was granted against a person who kind of declared her unwell, etc. Even dead.
Yes.
And all that was stopped. And Google tried to argue that our policy does not permit us to take these down. The only time we can take down something is when it is pornography of children. So the court got very annoyed with that, saying, this is no less than that. You're saying that a child has expired. You can't do that. You're causing so much of pain. And so they said, okay, give us 48 hours to take this down. The court said, no, immediately. Immediate means immediate. And the court declared, we have a zero tolerance policy when it comes to children. So, of course, the judges, if their heart and mind is in place, they're extending the internet torts, the newer ones, which look quite different, but at the end of it, it's all negligence, nuisance, and some of these older torts which we've all learnt in our tort law. So, what do you say about some of the challenges which you have been facing in patent prosecution?
So there are two or three important ones that I can probably talk about. One, I already mentioned about the obstacles that we have in the law itself, about the barriers to patenting in India in specific domains. Now, what we are seeing is that, I mean, I am a biotechnologist by training, so I can just list a few. So we have probably the top 10 biotech inventions of the century that have come up in the last few years. Given the law that we have, nothing can be patented in India as such. So you have to just go around some of that, work around how you can get, at least some protection for some of those inventions. Now, what could be the consequence of this? The consequence is that if you're not able to give some protection, at least the desirable protection to some of these, path-breaking technologies that are coming up in India itself, how will those companies bring those technologies to India? Or even so, even an Indian company, why would they be interested in even looking at some of those technologies? Talk about CRISPR, you talk about stem cell therapy, you talk about, AI, not AI, I mean, you're talking about all the different kinds of path-breaking, immunotherapy, you have antibody-driven therapies coming up. So many of those challenges are big-time challenges in India. And even diagnostic methods, things like diagnostic methods which are not really simple methods like imaging methods or X-ray methods or something like that, but where you have maybe 5 years of 10 years of research gone into developing a diagnostic method, that also considered not patentable. So, a blanket ban on something, and we do have now a couple of decisions from the High Court as well, where they said that there is no bar between an in vitro or in vivo kind of a diagnosis, which means that the argument was that this diagnosis is not being conducted on the patient's body, inside the patient's body, it's outside on a sample. So, there is no, and also it is probably not even leading to the treatment. It's a method which is a diagnostic method. It's not a diagnostic method which is leading up to treatment. But the evolving jurisprudence as of now is based on what the letter of the law is. That's the biggest challenge, that unless the law is reformed in some way, we might not see the end of some of these technologies in India. Also, on the administrative side, I would want to say that a lack of training, I would say that there is a lot of inconsistency in examinations still. We would say even formality objections, for example, are not getting settled even after 50 years of the law. Some of those challenges are still around. And I think those are the ones that probably in the next year, the Controller General is keen to look at some of those issues. Yeah.
So, Madhu, when we talk of training models in AI, we need a lot of data. And sometimes people struggle with where to find this data. Is this data still in copyright or has it expired? Did it not have copyright in the first place? Who does it belong to, etc.? Can you throw light on when copyrights expire and they go into public domain? Can you throw a little light on that aspect?
Sure, sir. So, public domain is not defined anywhere under the Copyright Act. But what is understood is that when the copyright or the term of copyright in a particular work expires, that work comes in public domain. What is essentially meant by this is that there is no copyright in this work, and hence it is open for anybody to utilize the work without seeking permission of the author or the owner. Because as we all know, copyright is also a negative right. So you cannot use any work till the time the term of copyright subsists without permission. Now, when a work enters a public domain, it is available and it is free for all. We have seen so many works developed, like the famous Donald Duck, the famous Mickey Mouse. all of these have been developed with the original works that were created in the 1800s, and as we saw that in the 1900s these works came into public domain. Now again, here there have been some discrepancies, or rather some questions or concerns. Like for example, if you take a cinematograph film, the term of copyright is 60 years from the date it gets published, which means the first commercial release of the film. So after 60 years, the film comes in public domain. And if you want to use, say, a clipping of that for any work, it is open. So many times, producers come to us and they say that, for example, Mughal-e-Azam, it is going to come in public domain shortly. Is there any way that we can protect that copyright, create a new work with using the same thing, so that we develop an independent copyright, like maybe something like a 3D version, a colored version, etc.? And our answer to that is that you may create a new work, and that new work may have a different copyright or an independent copyright, but still the original work will come in public domain, and it doesn't stop others from creating or replicating another work just like you have done. The other discrepancy is that while a cinematograph film may come in public domain, but the underlying works that go in it have different term of copyright. There, for example, if you take a literary work, the literary work copyright is for a period of 60 years from the date on which the author dies, which means that even if the film has released today, and say the author of the script dies 30 years later from the release of the film, the copyright in the script will be for 90 years from now, whereas for the film it will be 60 years. So while it will be open for somebody to use a clipping of that film, but if you want to use the script and make another work like a remake or a prequel or a sequel, you still need permission of the author of the work or the producer of the work. So these are some discrepancies which do exist in the realm of public domain. However, if an AI model uses a work which is available in public domain, we certainly don't have to worry about the issue of copyright infringement.
Thank you, Madhu. I'm going to ask you one quick last question, and then we'll see what we can do with one more quick round. You mentioned that there were 10 different biotechnology related technologies which were unlikely to be protected in India. Can you give me an idea of what these are?
Thank you. Sure. If you talk about, let's say, we talk about newer disease management therapies. So we are also moving from synthetic drugs to biomolecules. We're going to biomolecules. Now, when talking about biomolecules, those biomolecules could be made with different kinds of genetic engineering methods. You've also seen, some of the, you can have your own cells getting trained as vaccines, They are your own cells, so they'll draw up your own cells, they'll train them, your own fighter cells in the body, and they can get inside your body, they can be trained specifically for your body, and those can then protect you from a particular disease, let's say cancer or many other different kinds of diseases. Now, if you file a cell-based composition before the patent office, you're not going to get it because the section 3 has barriers for that. They don't allow it. Next is, for example, the method of transgenic cells or transgenic animals or organs or 3D, not 3D, sorry, the transgenics that could also impact agriculture, for example. Agriculture is a big deal in India, but you're not going to get any, patent on some of those transgenics. We also had, if you remember, sir, we had the Monsanto case in that. Now, the method of creating a transgenic cell is patentable. But you don't get a patent on the transgenic itself, which means the seed cannot be patented Now, how do you enforce it in the court of law tomorrow? So what is the use of having a method of transgenic patented in India when you don't have an extended protection to the seed itself? So some of these complicated things are there. So biologics is a bigger kind of a segment which gets directly impacted. Then I also talked about diagnostics. Now, for example, you're not a patient right now, but there may be a propensity for diabetes or cancer or cervical cancer or any other kind of an issue tomorrow, and you want to assess that. So there are technologies which are now available to assess that on a genome level. Now, some of those technologies are again falling under the ambit of diagnostic methods, whereas they're not actually diagnosing any condition which is presently existing in your body. It could happen sometime in the future, but even those cannot get patented in India as of today with the legal framework that we have. So some of these things, like stem cell therapy. Now, stem cells are your own body cells, and they can be trained, they can be actually engineered to even develop your own organ, replace a liver tomorrow, for example. Now, you cannot get a patent on some of these things because the restrictions in the law are such that they don't want to allow monopoly on any of these elements. And some of that goes back to when the act was getting enforced in 2005, the amendments, that we wanted to watertight ourselves against external transgressions, having monopolies from outside and so on. But I think the time has come that we need to relook at some of those. Thank you.
Thanks. That was very interesting. We have just about 5-10 minutes left. So let me open this to the House to ask any questions that you may have of our panelists. Yes, sir.
Very educative, illuminating session on a subject with which I'm not very much familiar with, but we keep on reading about it. Keep on reading about Mr. Praveen Anand's achievements in the court, and also Amit Naik's achievements in the Bombay and other places, and of course KNS are well known. We have spoken at length about the use and abuse of AI. I would like to know for myself, AI I know is a very wide field, and IPR may just be a component, you see, where it affects the intellectual property rights. I don't think that any remedies have been suggested how to meet, you see, this fake abuse, the abuse of AI so far as intellectual property is concerned. What safeguards we can have, what regulations we can have. I think that aspect also needs to be touched upon. And please don't bother about the time constraint, because this is a very important, vital topic where I would like to know the views of us.
So actually, today itself, the government has passed a circular. Can you give that to me? I just got to know while I was outside that today some law has been passed. I think it's a regulation. It's a mighty circular on fake news. Yeah, on fake news, just today. I know that's another interesting question. But I think even if you make a small start with a circular, then the moment the court starts to take notice, like on deep patterns, so this is, the notification says that there should be no bias or discrimination in AI systems that can compromise elections. Then, under development of AI systems cannot be launched without prior government approval, then watermarks need to be placed in news, fake news, so that you can know the source of the fake news. And so these are some of the highlights of the circular. But there are many countries who are now starting to legislate. I'm sorry. I'm sorry, sir. I had to come here being unwell. So I'm in a little bit of a quandary here. On the next seminar, which we do on AI, you will find a lot more on AI regulations. But the two broad things I want to say, there are two approaches. One approach is of countries who believe that we should leave the law to the market forces and don't regulate. The other approach is to regulate in each sector specific regulation. And the third approach is to have an umbrella AI law, which will govern all sectors. So China has followed the sectoral approach. So they have one law on deepfakes, one on bias, one on something else, different laws. Whereas France has got an umbrella law. And so India right now has come up with something on deepfakes, and they've come up with something on dark patterns. Dark patterns are very, very interesting. For example, suppose you advertise. You may have seen that when you go to New York, there are stores which say, going out of business, 1 day left. And they attract customers by making those kind of false representations. That's called a dark pattern. You must see the dark pattern regulation issued by the Department of, I think it's Consumer Affairs.
Yes, that's right.
And you must see the examples given in the annexure. Those examples are very interesting.
So we used it in our Anil Kapoor matter also.
Yes, and I think the judge in the order also mentions dark
about
pattern.
it. Yes.
Yeah. So in the next couple of months, sir, you'll find a lot of legislation or circulars, position papers. In fact, at one some few months ago, a minister made some speech, and his speech became the subject of discussion. And a lot of people were treating that speech as the new law. Then I remember some of us had to go and write that this is no new law, this is just a speech by a minister. But that's how it all starts, I guess. And it will happen. So, is there any other question? There's one there.
Copyright is applicable like anything, writing a book or any something, but creativity is like process which is getting very.
So, at a fundamental level,
Yeah.
At a fundamental level, you can imagine that one relates to the world of science, which is patents,
Okay.
and one relates to the world of art, which is copyright, at a very, very fundamental level. And so you have something which is a writing or a poem or a play or a song, lyrics of a song, a melody. All that are subject matter of copyright. Whereas if you have a new invention, then that's the subject of a copyright, which is of a patent, which is functionally useful.
Okay. So,
Not aesthetic, but functionally useful.
yeah, got it. But what is the expiry of a patent if I file it today? How long it is going to be safe? Or, when it will expire, 10 years or something like that?
20 years from the date of filing.
After that, it is free.
Yes.
Okay. And ma'am, the other question you said, like transgenic and genetic alteration and all that. So that is not patentable here because government doesn't want to allow genetic alteration or GM crops or whatever. Or there are other regions here in India not to patent that kind of stuff.
So there are several reasons around it. One of them is that there may be also it's a highly regulated market as well. You cannot have GM food is not approved for circulation in India, for example, for consumers. But at the same time, the law also does not allow monopoly on some of these things. For example, agriculture, method of doing in agriculture is supposed to be, made free for everyone. So if somebody wants to monopolize something, those are the barriers in the law. At the time when these barriers were put, they couldn't have envisaged that the technology will become so sophisticated, so scientific. And so it's now applied to everything. So if the reform is going to happen, it can help some of those technologies come out.
Okay, like herbicide tolerance and all that, that can't be patented here.
So there are different ways of methods are patentable, but products as such may not be protected in that sense. Somewhere methods are protected, somewhere products are patented. So it depends upon case to case. I can't give a real answer to that right now.
Okay,
Yeah.
thank you. Thank you.
You know that this panel charges 100 rupees per question. So
Thank you.
Where?
So first of all, it was an excellent session. I think all three of you did a wonderful disposition on the subject and covering different aspects of IPR. Could you throw some lights on the food recipes? I know it's a pending case in the High Court, and but this has always come about time and again in over a period of time. And what really originates, because this. Some families claim that's their recipe, or some geographical regions claim priority over that. So how does it really work? I just wanted to have your expertise on what could be.
So I must tell you that I've been in practice for 44 years. And in 44 years, I've done very good cases, and they've received good publicity, newspapers, television, etc. But I got involved in this butter chicken case. And this one butter chicken case has not even been decided. And it has got more publicity than all my cases put together. It's come on New York Times. It's come in Wall Street Journal, BBC interviews. I mean, there are everywhere. I went to 3 countries after the last date, and everybody had heard about it. Front pages of Dubai Times, front pages of various newspapers. And of course, the reason is that I then discovered that food is very, very close to man, which is true. Food recipes, I mean, I'm acting for the defendant. And so I'm not saying that our stand is the right one. I'm not saying it's wrong. I'm not saying anything. Matter is sub judice before the court coming up at the end of last week of May. But I can tell you one thing, that food recipes can be protected by patents, but only if there is some novelty, utility, and non-obviousness. And in a food recipe, to prove novelty is very difficult. Very, very difficult. Because you have to either show that a certain kind of meat was not possible to eat because it was so hard, and a certain process was used to make it edible or some such thing. I mean, you have to reach that kind of level just because it tastes better. For example, red velvet cake. In our times, red velvet cake was not known. Or caramel, salted caramel. It was a relatively new flavor, right? It's only come in the last maybe 20 years.
Yeah. Also, sir, because there's every recipe, even in Indian households, if you have a Punjabi family, two different Punjabi families will cook certain things differently. So it's such a varied thing that, and in patents, I think the bar for proving something is very different from the existing one is quite high. So to get a patent on a mere tweak of a recipe, or you put one more ingredient, or you cooked it less or more, it's very difficult to prove that in a patent perspective. But maybe on branding and trademark and everything, of course,
Yeah, I
that,
was
that
just
is
coming
that
to
is.
that. So it's like if you make a compilation of recipes and you put together a book or something with a certain presentation style, pictures, etc., that becomes subject to copyright. And also, if you create a brand under which you do it, then again that is trademark and copyright as well. So while the individual recipes will be subject to whatever sir and she said, but the compilation certainly will be subject matter of copyright.
But I found one patent for a food recipe, which was a cake which had different density layers in the cake. So there was a soft portion and a hard portion and a soft and a hard, like that. And for that physical configuration, there was a patent that had been granted for that structure of the cake.
Even internationally, we have not seen a lot of such recipes getting patented. And this was, in fact, one of the resolutions in one of those international associations that people are trying to figure out how to take out this as a resolution, what to do on this. But it's as he said, it's not very easy.
But thanks a lot for giving us an appetite. All right, I think there's one more. Yeah, please.
Hi, sir. My question is, I'm a film director and writer myself, and I have a question because I'm making a film for the wine, and it's based out of Israel, and currently I'm working on this project, and my writing has been done, and soon I'm producing this film, start the shooting, and my question is, what I wrote about this wine and the yard and the place it's belong. It's very diverse. Israel is very diverse country, and how they produce a wine over there. So my script is I want to be the script has to be safe. There has to be copyright fully, and how I can track my story beyond the border, and how I can make a contract with my client, strong contract, strong collaboration, so that in the future we have a long association. So please.
The first registration of copyright is not mandatory in law. The moment the work comes into force, the copyright subsists in that work and you're able to take protection. Unlike a trademark, where if it's not registered, you can't seek an action for infringement. Then you can only seek passing off. But the remedy of copyright registration is available whether or not you register your work. However, even if whether you choose, so one way of protection of your script, because you've already worked and like you said, you've created, it's a very diverse place, and you've collated a lot of information, you've done a lot of research, a lot of work has gone behind it, so you should certainly register. The other thing is that there are various associations, like trade associations. They are not statutory bodies, but they do register works like copyright scripts and all for writers. So for people who don't go for copyright registration, they just stamp it and it gives some authenticity that this particular work is authored by you and on a certain date. But what is very important is that when you share your work with somebody, because now is the time when you will probably start approaching studios, investors, etc., to produce your film. So at that stage, when you share your work, it is very important to have the right contract in place. Whether it's a non-disclosure, confidentiality and non-disclosure agreement, to a full-fledged writer agreement, you need to make sure that your document is properly worded. Also, many times it happens that, as you know, that there's no copyright in an idea. The copyright is in the treatment, it's in the expression of the idea. So tomorrow, even if you share that script with somebody, it is possible that they may not enter into agreement with you, but they may develop something independently on the same issue because the facts are available in public domain. So at that stage also, for you to protect your work, if your contract is strong enough, you'll be able to do so. So it's very important. There were times earlier when, people used to just exchange without having any email, any contract. It was all a word of trust. But that time is not there now. We've seen multiple cases in court and courts have given more recognition to breach of confidence, even in protection of ideas, which otherwise are not protectable under copyright. So if you share a brilliant and novel idea with someone and you do it under a contract of confidence, and somebody takes away that idea, and before you can do something or give some tangible expression to it, somebody's stolen and made another work out of it, you can surely get protection on that also.
Yeah, thanks. And my next is like how I can make a strong contract. So,
You can contact us for that.
sure, certainly.
Right. That's what I said. The trade associations. It's called the Script Writers Association. So we could definitely help you with that also.
I think we've finished our time. Let's wind up. Mr. Bhasin, let's give our panelists a big hand.
I think a brilliant session on a very, very important topic, which also dealt with artificial intelligence, which world is talking about, not just India and not just this panel, but we got some very useful ideas. And I'll take it from you that after a couple of months when we have another event, you will speak also on the remedies you see to cure the abuse of artificial intelligence. No one denies the use and utility of AI. It is there. We have to live with it. But the abuse of it, that requires consideration. A big hand to the just a presentation of my mentor.
Mr. Praveen Anand.
We start with the last session, very important session which interests, I think, all of us. Data protection and privacy issues. And this is being chaired by one of the most distinguished lawyers of the country, Ms. Leera Goswami of the Associated Law Advisors. We also have the distinguished presence of Shobhit Chandraj, Khaitan & Co., and Mr. Samit Gambhir, a dear friend, also Vice President Corporate Law of DCM Shri Ram Limited. We have a distinguished participant from overseas, Ms. Donata Stroink-Skilrud, President of Termageddon LLC from Illinois. I request all of you to be seated. Please, someone can go out and tell the people that session has started. Can someone go out, please, and tell? Please sit down. Please take your seats. Has she joined? Donata? Yeah, so they have to take steps to join. Will someone tell the people they are standing outside to come inside now? So why are people going out? Donata hasn't joined yet. So I think you can start the proceeding. Over to you, Leera. Thank you.
Good evening, everybody. This is Leera Goswami. I'm a founder partner at Associated Law Advisors. So I head the corporate and regulatory vertical. So there's always the danger of less people and ready to leave when you're the last session, but hopefully the topic will keep you engaged. We have a distinguished panelist here. I have on my right Shobhit from Khaitan, and I have Shamit he's an in-house counsel with DCM, and I think we can briefly introduce ourselves. And Donata is joining us from the US, but I think she's not yet come, so we'll introduce ourselves first. And then I will give an overview of the evolution of the Indian laws on privacy and data protection. Donata will do likewise for the US, and then Shamit will give the background from a perspective of in-house counsel, with Shobhit, giving us the perspective of how the interplay between the existing and the law, which is yet to become effective. So I think we have Donata here, so we'll go with her. Hello, Donata. you can introduce yourself, and then after you, I'll go.
Hi. Hi everyone. Thank you so much for having me here. My name is Donata Strings-Gilrude, and I'm an attorney licensed in Illinois, as well as a certified information privacy professional. I'm the president and legal engineer behind Termageddon LLC, which is a software as a service that has generated tens of thousands of privacy policies. I'm also the co-chair of the American Bar Association's e-privacy committee, member of the ABA Science and Technology Council and the ABA Cybersecurity Legal Task Force, and I'm also a fellow at the American Bar Foundation as well.
Thank you. So if it's okay with everybody, I'll just give a little overview where we are today. The conversation regarding privacy started many, many moons ago. Actually started when we were starting to become an independent nation. And in the 50s, the Supreme Court held that it was not a constitutional right. Privacy was not recognized. And then in the 70s, we had the cases regarding surveillance, where the police officer came and knocked at your door, your neighbors looked suspiciously at you, and the Supreme Court said that the right to privacy was implied in the right to free movement, life and liberty. And then 42 years later, we finally had it from the Supreme Court, a 9-judge bench saying that it is an integral part of the life to liberty. And that's a very interesting judgment because it deals with different facets of privacy. Informational privacy. You have information about yourself, you give it to a bank, you give it for a specified purpose, the bank gives it to a regulator. We have a breach of privacy situation. We have a way of dressing. We want to express ourselves. We have certain symbols belonging to our religion or to our community or to our preferences that we want to show on our sleeve. That's an aspect of privacy. So the law has evolved and is still evolving. The right to marry, Supreme Court has said we don't have a fundamental right to marry. It remains to be seen what happens later on. But as of now, Supreme Court has sort of stepped back on that. The law of data privacy evolved because in this final judgment, the Supreme Court said that informational privacy is a facet of privacy and the government should come up with a very robust data privacy law. That led to the first data protection bill in 2018. We had a government constituted committee, the Sri Krishna Committee, which gave the first draft, modeled primarily on the EU regulation then, GDPR. That led subsequently in 2019 to the first government-sponsored draft, again modeled on EU and the 2018 bill, but it was withdrawn. Then there was a big debate, and the focus of the law has now changed. So it's a softer touch. The compliances are simpler, mainly on data fiduciaries who process data. And you have another category of significant data fiduciaries who have slightly more enhanced obligations, like to appoint a data officer in India, to do a data audit and in India, and there are other compliances regarding consents. So from 2018 to 2023, we have now what we call the Digital Data Privacy and Protection Law, which deals with processing of digital personal information. It can be anything that identifies you. Identify a number, like we have our permanent account numbers, our Aadhaar numbers. It can be your password, it can be your email ID, anything which capable of identifying you. It has to be in digitized form, or it can be non-digitized to be subsequently digitized. So all of them are protected. Until now, for more than 2 decades, we have the Information Technology Act, and that protected data breaches, that protected personal sensitive information like what I just described, through a process of adjudicating officers, and Shobit will deal with that interplay subsequently, so I won't deal with it very much, but suffice to say that held sway for the longest time. So if you had a data breach, the data adjudicating officer will adjudicate. That criminal procedure of penalties still survives, but the compensation part has been taken away. So today, under the new law, the Data Protection Board, which is a very different sort of regulator than what was contemplated initially, it's not an independent regulator. It does not have powers to frame regulations. It does not have powers to prescribe a code of conduct, but it can look into data breaches. Remains to be seen how it interfaces with cybersecurity authorities, CERT-In and others, which Shobit will come to in a moment. But I want to just describe for you and sort of give a bird's eye view of some of the good provisions, some of the not so good or bad provisions, and some of the provisions was a kind of ugly, the good, bad, and the ugly. So the good part is we have a law. It's not yet enforced, but we do have, so that's a good part. The good part also is that it's moved from the criminal penalty regime to a fine regime, so that's a good part. It's also soft for compliance, so makes compliance easier. And enhanced compliance obligations are on significant data fiduciaries. So there is a distinction there. Data processors, for instance, a fiduciary is the one who processes your data, and he can do that directly or through a data processor. The processors don't have much obligations, except possibly via the data fiduciary. So the data fiduciary could pass on obligations contractually, but the law does not impose directly on them any obligation. So we have a regime which is fairly simple, but it requires two main things. It's first focused on digital personal data, digitized form, or anything to be digitized. Two, it allows processing with the consent of the data principal, or for some legitimate purposes. And legitimate purposes is defined. It's anything which the law requires you to do. Any legal obligation that you have to follow, that's exempt. You don't need consent. That can be done. Then anything dealing with sovereignty of the state, national interest, law enforcement authorities, all of them are doable. Anything relating to employment, for instance, an employer processes your data for purposes of giving you an employment benefit, or to protect itself, or to protect confidentiality or IPR. They're all legitimate uses. The state processes your data to give you a benefit, to give you a license, to give you a certificate. All of them are saved. So it hinges on consent, and consent is for a specified purpose. If that specified purpose is over, you're supposed to delete it. If the data principal revokes consent, you're supposed to delete it. You're going to ask the data processors to delete it. So it's a fairly simplified regime, but the consent is to be managed through a consent manager, through an interoperable platform. So you need to put in place that kind of interoperable platforms, and you need to put in place data privacy policies, and you need to make sure you appoint the right officers, depending on whether you're just a data fiduciary or a significant data fiduciary. So we are in this transition stage where the law is there, but not yet implemented. The law will come into force from a later date to be notified, and we are still awaiting the rules. So in terms of regulatory things to expect, I think one is the constitution of the Data Protection Board. The other are the detailed rules which we can expect. And then we can expect a lot of flurry of activities in businesses where they are looking at their privacy policy, they're looking at all the interfaces that you have with the consumer. Should I have a pop-up here? Should I have something to show here? Should I take consent? Even for legacy data, data that you've collected before the act came into force. All of it needs to be covered by express consent, and the consent has to clearly seek consent. It has to be informed consent. It has to tell the specify the purpose for which you are going to process. You're going to tell them what the processing activities are. They have the right to withdraw consent, and also that the grievance mechanism, you have to set in place a grievance mechanism, and you have to tell them what is the way of going about. So there will be a lot of work, and there'll be a lot of regulations that we are expecting, and it also remains to be seen what will happen. And I think one of the things that will happen is going to be enhanced privacy challenges. Challenges which remained dormant or people were not very aware of, people what took for granted. For instance, many times in internal investigations, employer would ask for a device, and the employee would give the device. And the device would often have work-related. It may be a the employer-owned device, but it also had personal data. You would sometimes image it, delete that. Employee didn't complain. We're seeing more and more occasions when the employee is resisting, employees unwilling to give devices, even for internal investigations. Background searches, if they become too intrusive, going to your home, finding out about you, that could lead to privacy challenges. Vendor machines, if they're going to take your picture, you're going to have issues. We are already seeing that. So I think with that, I'll request Donata to give the perspective from the US standpoint. Thank you, Donata.
Sure, thank you. Let me just share my screen because I do have a little presentation to help us kind of keep track. Yeah, so I will be going into the data protection laws and privacy issues in the United States. So a little bit of overview as to the system we have in the United States, which is a lot different than other countries. So federal privacy laws. So right now we have federal privacy laws that cover certain types of data or certain activities. So for example, we'll have a privacy law for healthcare data, for financial data, the data of children, or the data held by governments. But as of right now, there is no federal privacy law that protects personal data commonly collected through business websites. So if somebody's collecting names, emails, phone numbers, IP addresses, or tracking somebody through analytics or through advertising, there's really no federal privacy law for that at this time. We have had federal privacy laws like the ADPPA being proposed, but they haven't passed yet. And from what it looks like on the Hill, it's pretty unlikely that we're going to have a federal privacy law in the United States anytime in the very near future. And this makes compliance really difficult. So the lack of a federal privacy law has created the state law patchwork. And essentially what the state law patchwork is the fact that each state is proposing and passing its own privacy law. So we started off in California in 2004 with the California Online Privacy and Protection Act. The purpose of that law was to protect residents of California and make them more comfortable shopping online, because a lot of people were very concerned about their data when they were shopping online. So that was the purpose of this law. That was the original one, and we've really kind of went forward from that. So we have multiple laws in California. We have laws in Delaware and Nevada. And now, there's been a lot of laws that were passed that went into effect last year. So Virginia, Colorado, Utah, Connecticut, And then we have a whole slew of laws going into effect next year in 2025. And we'll see what happens in 2026, 2027, and 2028. So basically what this is meant to illustrate is the fact that in the US, since there is no federal privacy law, we have a lot of state laws. And a lot of them are different and a lot of them are similar, but that's what makes compliance so difficult in the US, at least with the US privacy laws. Also, a lot of these aren't well established. So we have the text of the law, but we don't quite yet have any regulations, any guidance, any enforcement actions or anything like that, because some of these have not gone into effect. So again, that makes compliance very difficult because you don't know anything apart from the actual text of the law, which is a lot of times confusing and hard to understand. So some common features between privacy laws in the US. So some laws will apply regardless of business size, but most of the newer privacy laws will apply based on different factors like revenue size, the amount of data processed, or the percentage of revenue derived from sales of data. So if any of your customers are doing business in California, for example, you can't just assume that California's privacy laws will apply to them. You have to actually check the factors. Most privacy laws in the US feature an opt-out model. So in Europe, for example, we have an opt-in model. That means that data can't be processed until somebody opts in. In the US, we have more of an opt-out model, which means that data can be processed until the individual objects. So for example, I can send you email marketing without your consent until you tell me to stop. Opt-out is very popular in the United States. So we have opting out of sales of personal data, opting out of targeted ads, opting out of use of personal data for profiling. We're also seeing more movement towards universal opt-out mechanisms. The California Privacy Protection Agency has released requirements for browsers to create universal opt-out mechanisms where a consumer can actually opt out once, and then that mechanism is brought to multiple different websites so they don't have to do it multiple times. Also, one right that's kind of interesting in the United States is the right to not be discriminated against based upon exercise of privacy rights. So that means you can't offer poorer services or higher pricing or anything like that as somebody who exercises their privacy rights. But we also have a huge exemption for loyalty programs at stores. So it's yet to be seen how this will actually play out in practice. Another thing that's interesting in the United States is that we provide a right to appeal a decision made on privacy rights. So if a business has denied your request or partially denied it, you can appeal that decision, but you appeal it to the same business that you exercise your privacy rights with. So not quite clear as to how useful this is actually going to be. And then also you need to have a privacy policy that includes very specific disclosures, and each law has different disclosures that it requires. In some areas, a data protection impact assessment is required for higher risk data processing, like profiling or sales of data. And then our privacy laws are usually enforced by state attorneys general, except for the California Privacy Protection Agency. This means that there's not a ton of resources that's being dedicated to the enforcement of privacy laws. So it'll be interesting to see whether we have any strong enforcement of these laws or whether enforcement will be weak. But there are a lot of differences in privacy laws as well. So each privacy law has its own definition of who it applies to. Different laws define different terms in different ways. So for example, sale or sharing might be defined one way by one law and another way by another law, which makes it extremely confusing both for businesses and for consumers. Different time limits. So some privacy laws will give you 30 days to respond. Other laws will give you 45. So you have to resolve those conflicts as well. Each privacy law has a different requirement for what a privacy policy needs to include in its disclosure list. They each have its own set of privacy rights. Some of these differ, some are the same. And then we have a different set of requirements for controllers and processors. So again, really difficult to comply with all the laws because there are so many differences, even though you can resolve them, but it does make compliance very difficult. Now, we also have a ton of proposed privacy bills as well. So any of the states that haven't passed their own privacy law, they don't want to wait for the federal government to come in and pass a federal privacy law. So they're proposing and passing their own privacy laws. So you do have to track these. If you are working in the United States, you do have to keep track of these to make sure that you have a good understanding of what's to come. You'll see that New Hampshire here is in bold. That essentially means that that's the bill that's the closest to passing. So it's up for the governor's desk right now. So we'll see, hopefully in the next couple of weeks, whether he signs it and what that means for compliance. Obviously, it means a more difficult compliance patchwork. So some key takeaways for you. So the United States has a patchwork of privacy laws. This means that you have to first figure out what laws actually apply to your client, because if you don't do that, that will make it impossible to comply, because each privacy law is different, right? So you have all these different requirements. You need to figure out which ones actually need to be met. Don't assume that because your client is in California that you need to comply with California's privacy laws. That might not be the case because of the business size limits. Also, don't assume that your clients will not have to comply with laws if they're not in the United States. A lot of them are very broad reaching. So you can, if you're doing business there, like you have customers there, you're collecting personal information there, that's something to keep in mind. You may need to comply with those as well. The patchwork is increasing, so we're seeing more and more of these privacy bills being passed, increasing this difficult patchwork. And then also the tracking of privacy bills is crucial. Don't allow yourself to be surprised by any of these bills. A lot of times in the United States, we have a small amount of time between passage and enforcement. Usually it's about a year, sometimes less. We also have regulations that come out that sometimes go into effect 2 weeks later. So you really have to be on your toes there and make sure that you are properly tracking everything. So that's my quick overview. Thank you so much. If you have any questions, definitely feel free to email me. And then also, if you would like to learn more about U.S. privacy laws and compliance, or have any questions, or would like to network, I would definitely encourage you to join the American Bar Association's e-privacy committee. We'd love to have you, even if you're not located in the United States. Thank you.
Thank you so much. Just one question. I wanted to have an idea if there are case law or if there is statute on the kind of damages for breach of data, because our regulator has very large leeway for data principles. It's a 10,000 rupees. It's a fairly nominal amount, and it goes up to 2.5 billion for a data privacy breach. For instance, if you fail to take consent, or we have a very different punishment if there's a prohibition on tracking, monitoring children, or not getting consent of guardian. And if you fail to do that, the damages can go up to 2 billion rupees, so about 18 million USD. So very large damages. Is that common in any of the jurisdictions in the US?
For data breaches, yes. So I would encourage you to first take a look at the Federal Trade Commission's website. So they work with a lot of these types of cases. And yes, damages are very dependent on, the type of data that was breached, how it was breached, what actions the company did or didn't take. So there are a lot of factors that go in, which means that damages vary widely, but they can be in the millions of dollars, absolutely. So that's something to keep in mind. The Federal Trade Commission enforces some laws, as well as state attorney generals enforce other laws as well. And sometimes they can band together to create a lawsuit or an action as well. So we do see a lot of data breaches. Lately, we've seen a lot of issues with tracking as well. So tracking people online. DoorDash, I believe, was just fined for tracking people without their consent. Which is very interesting because they're using a privacy law that was created a couple of decades ago to prevent the monitoring of phone calls, and they're using that to bring these lawsuits. So yeah, there's a lot going on always.
Thank you. Thanks. Shamit, do you want to give the perspective of Indian companies? How do they perceive this? What kind of compliances you're doing to get up to speed? It would be helpful to know that.
Sure, Lira. Thank you very much. I'm indeed very privileged to be here. Thank you, Dr. Basin, who's our guide, philosopher, and mentor of industry, in fact, Thank you so much for having me here. I think it's very, very relevant topic, but the point, from the in-house perspective, I think I have a lot of questions, a lot of compliance issues, a lot of doubts. But the point is that the devil lies in detail. So we are still waiting for the rules. We're still waiting for the other things, the Constitution of Data Protection Board and all. And then perhaps we'll have a lot of clarity on certain questions. But from the compliance perspective, I really think there's a lot of open areas, a lot of gray areas as of now. Data is, definitely personal data is a very, very powerful thing, and I understand we casually give our data to someone, but we don't realize the power of the data with someone. Where someone is utilizing, one's data actually is very, 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 difficult thing to understand. It reminded me of a small story actually. I was talking to somebody yesterday who's a dealer in art actually. So we're just having fun. So he told me a story. In fact, there was an art dealer, who had a gallery and who was used to sell original arts people. So one day, one gentleman came to him and he says that I am told that someone, the artist, when he dies, the value of the paintings actually go up. He says, yeah, it's very, very usual. After the death of the artist, the value of the painting is generally very, very high. And he says, okay. So the next day, there's another guy, young artist, came to the gallery, and he was trying to put his, paintings in the gallery. So he says, I have a couple of paintings which I have done, original paintings, so I wanted to put in your gallery for sale if someone is there at the sale. He says, fine. After a couple of days, this gentleman, the artist one, who went to the gallery and he says, sir, any idea, any update on my paintings? Is there any taker of my paintings? He says, I've got a good and a bad news. The good news is that all your paintings have been sold in a single day. But the bad news is the guy who bought your painting is your doctor. So the point is that, because he has all the data, this is the person is going to die perhaps, So the point is the data, personal data can do one. Actually, data has a lot of weight, a lot of things. So from the in-house perspective, what I'm saying is that we still facing a lot of open issues. For example, one and the foremost thing is that awareness and the trainings, which we're still thinking, because we have done a lot of other compliance things. Every day we have a new compliance to implement, and we have been facing since so many years that this is a new compliance and you have to do the implementation, training, awareness. So kai baar to, sometimes it looks like there's something coming from the compliance, oh, another burden, so every employee start thinking like that. But how do we take the employees together for this is very, very important. So one is that the awareness among the employees, training among the employees, the regular training and monitoring of that is very important, because then only you will be able to comply with the data protection laws. Now, data is everything, business people, marketing people, sales people, everyone need to understand the importance of this rule first, because there is a lot of burden, heavy penalty on the organizations on this. So, for example, how do we do the trainings, the regular monitoring, awareness? The second important thing is, what I'm thinking is that we have a country of 1.4, 1.3 billion people. No organization like us, or maybe no other organization, we deal a lot with the farmers in our agro products. We have sugar mills. We interact a lot with our farmers to tell them the tips, give them the tips for the good product, other areas, other, even ESG things, related things, environment related things. We interact a lot with, thousands of millions of people, the farmer, the agricultural people and all. Very difficult when you have a lot of data. How do we get the consent for these rural people? How do we ensure that all of them are actually aware of this rules and regulation and the privacy things? So to create awareness among all these people is also the facing. I'm thinking there's a lot of challenge will be faced perhaps. Let's see how the rules comes out, who are exempted, who are not exempted. So therefore, employees training, training of your potential people, then telling them that this is what is important, then taking their consent from the rural people, farmers and other people whose data we are carrying. So that's one thing which I'm thinking. The other is, law says that whenever there is a data of a child, you need a parental guidance or a consent, which again has a lot of issues. Because if you're taking the consent of a parent, that means you're taking the data of a parent also at the same time. So how do we handle that also? Number two, it says that any detrimental thing, you have to say take care of the well-being of the child, etc., etc. So there is no criteria for that. Perhaps rule will have something. So what do we mean by what is detrimental to the child's well-being? What is not? It's another area of debate. So there are many open issues, and we are at a very this stage that really I can't say that how much answer we have, how much issues we have, but definitely till the rule comes, will not have so many answers. The other thing is, who will be the DPO? Who can be the DPO? For example, my organization is a significant data fiduciary. What all things I have to take care additionally to my employees, to the other things? Who can be the DPO? Who will be the auditor of the data? Can my CIO be a DPO? Can my CRO be a DPO? Can my chief technology officer be a DPO? Or we need to have another person? What kind of a qualification? So I think what we need is basically what I'm thinking right now, how to mitigate things and cope up these things. Take out some GDPR related issues, take out some GDPR related case studies to initially train them and to make them that, be ready. These are the kind of law we are going to have soon in our organization and our country. So I think these are some of the issues which from a practical perspective, unless and until we have the clear idea, seems difficult, because, and then government has a lot of exemptions. So, what will the impact of those exemptions? Plus, the act doesn't apply to the public domain data. So what will happen? Can we use that public domain data, or it's only the views right we have? So all these things, I think, we'll have to wait till the rule comes, frankly. Lira?
Yeah. So yes, I agree with you that the devil lies in the detail. And interestingly, the government, the state, and not just the state, but all instrumentalities of the state are exempt. So, and the Right to Information Act is excluded. That's the ugly part of this. So the non-transparency is the ugly part. There's great discretion on the federal government to exempt anybody. And there's no criteria given, so very wide discretion. Then the government can maybe say these startups won't, but what happens? I mean, it may not be level playing field because straight state instrumentalities could be any public sector corporation dealing with data. So, I mean, it's unthinkable that they should be exempt. So that's not a very happy situation. The other thing is it's not an independent regulator. So what will happen where it's not an independent regulator? It's dependent entirely on the government for framing regulations, for financing, and for manpower. So these are the bad and the ugly bits of this piece of legislation. And it remains to be seen because it's only digitized personal data. What happens if there's a data breach involving a computer resource, involving a much larger scope where multiple authorities will come in? Of course, the data, to the extent this act applies, it'll override other laws. But there could be a lot of interplay, and so it'll be interesting, Shubhit, what you have to say.
And also, just one more thing, and also as of now, there's no clarity, in what time you have to report the breach.
Yes.
And also, what time you have to respond to the request of the data principal. There is nothing, no
the
clarity on that.
you're absolutely right, because this is, the CERT-in has given you a time frame, and if this is pertaining to digitize, then there is, right at the moment, there's no clarity whether you will only do it for certain or not. So Shobit, you might want to deal with this.
Sure. Thank you so much for that, Lira. And first of all, thank you so much for this wonderful event. It's great to be here and talk on a subject which is so pertinent as well as very relevant in today's day and age. My fellow panelists have, of course, shed light on how the law has evolved in the country and what impact it has today. And of course, we've seen similar trends emerging in the US as well, as Donata had walked us through. There are, of course, a lot of challenges that lie with the implementation of the new law as it approaches, and there'll be a lot of factors that will come into play in terms of how organizations carry out their day-to-day businesses as well, and particularly because when it comes to data, the general approach is the more the merrier. But I think this is one legislation which calls upon all organizations to really pause and think about what kind of data they're using, what are they going to put it, what use are they going to put it to, how are they going to store it, how are they going to share it, and most of all, how are they going to secure it. So I think with that, I'd really like to lay emphasis on the particular aspect of personal data breaches, because I think that is something that transcends all kinds of organizations today, and nearly every second day we hear about a news report regarding a data breach that has happened, which has impacted several people. And of course, as Lira was mentioning, we have a huge amount of digital data going around, and that digital data, of course, simplifies a lot of things, but again, makes it prone to some sort of breach and a security threat. So just starting off with trying to understand what the current regime really holds for personal data breaches. So at least as far as specifically personal data breaches go, we don't really have too much of a dedicated framework, but at a much larger level, when we talk about cyber incidents or cyber security incidents, which in turn can include forms of data breaches and data leaks, are required to be reported to the Indian Computer Emergency Response Team within a time frame of 6 hours of them occurring or you being brought to the notice of that. And that obligation really lies on any person who notices that breach to begin with, and it can't be contractually flowed down to, say, one of the parties. So that is absolutely one critical compliance that I think, like I said, transcends all organizations because the requirement applies to all body corporates in India, and even those that deal with Indians' data abroad. So the 6-hour window, of course, is a steep requirement that needs to be complied with, and that would act in conjunction with a lot of the requirements that exist in sectoral laws and regulations. We've seen the SEBI and RBI come out with similar reporting requirements as well. And when the DPDP Act takes its full, comes into effect in its full form, and when the Data Protection Board of India is also up and functioning, there will be a requirement that will stem under the new law as well. And what that will do is, given the definition of personal data breach that exists in the DPDP Act, even an accidental disclosure, which then has the effect of compromising security, integrity, or confidentiality of that data, is liable to be reported. So fathom a situation where you're sending an email internally and you end up marking the wrong person. So to that person, you've disclosed another person's details, namely the email address, or it could be the contents of that email as well. But again, that's something that has happened accidentally and you didn't wish for it to happen, but the law doesn't draw that threshold or allow you that exemption. In that sort of situation, there will be a requirement to notify that breach to the Data Protection Board of India, as well as the impacted individuals. Now, if that scale is much larger, that could translate to probably thousands or even tens of thousands, millions that get impacted. So in terms of compliances, of course, that is something that organizations will really have to step up and take notice, build those kind of mechanisms to help them meet those timelines and requirements. Of course, as Shamit said, right now the rules haven't really delved into what kind of timelines may follow, but from what we've been hearing and taking cue from some other regimes and jurisdictions, there could be a likelihood of a more of a immediate reporting requirement with some basic details, followed by a much more robust and detailed report that has to be furnished within a fairly longer time span of time. So these are things that everybody will need to gear up for. And importantly, the law really doesn't carve out a materiality threshold like we've seen in jurisdictions like, for instance, under the GDPR. So there are, under the GDPR, instances where you don't have to report it to the individual, where the authority may feel it may not be so impactful. But that sort of an exemption has not been granted under the Indian law, for instance. So, and again, there will be this regime that will come into play when the law takes effect. and whatever I'd said about the Indian Computer Emergency Response Team as well. So those will coexist, and on top of that, there could be sectoral requirements as well. So organizations need to be capable of handling multiple reporting requirements at the same time. And of course, I mean, these are things that we need to be, keeping up with. In terms of the other compliances in this regard, of course, organizations are also required to implement reasonable security safeguards to avoid or prevent data breaches from taking place. Now, what those safeguards would be, of course, have not been spelled out as yet, but the rules will shed some light on that, and probably organizations would have a much better idea. But I think that's where the classification between a data fiduciary and a data processor also becomes relevant, because what the law does is it encompasses, or it sort of obligates the data fiduciary primarily to undertake all compliances with regard to reporting as well as implementation of these safeguards. Of course, contractually, they need to be flowed down to the data processor, which will again mean that, the data processing contracts that exist between fiduciaries and processors will need a close look in terms of how these reporting obligations, as well as other obligations relating to providing necessary information and so on and so forth, will have to be kept watertight and absolutely flowed down in a very clear manner. So these are all, I think, important takeaways for us from a personal data breach reporting point of view, and build in processes that will help us, stay ahead of the curve as the law approaches.
Yeah, I think it's very important. It's very important to understand eventually, because if you're to comply, the law must be simple and easy to comply. So when you have multiple organizations involved in the similar issue, like a data breach is specifically one of the mandates of CERT-In. So how do you, have, and how do you comply with, who do you report to? Do you report to both or one? And who's going to be more effective remains to be seen. It's interesting. I just wanted to deal with one aspect, that it says anything that the law legally requires you to do is sort of a legitimate use. Recently, we had a decision of the Supreme Court, and it was a very significant decision in the sense that it declared unconstitutional electoral bonds. These were anonymous electoral bonds which were introduced by the government to fund elections. You could not disclose who the purchaser is, and it was all issued by one bank, the State Bank of India. And after many years, about 4 or 5 years, the Supreme Court held finally that it's unconstitutional. And it's directed the State Bank of India to disclose the names of the purchasers and the party to whom the donations have been made. Now, if you look at it, the law, the directions and the judgments of the Supreme Court are law. They are not statutory law, but they're declared to be part of law under the Constitution. And yet the Supreme Court says to a bank, disclose the name of your customer, which is a big breach, not just of its general fiduciary duties, but also would be of privacy of that customer, because he's given it for a particular purpose, has not given it for any other purpose. So I would see that even in this situation, the Supreme Court judgment is capable of review, certainly is going to be reviewed, and there would be significant privacy challenges in situations like this. Or in situations, say the law enforcement agency tracks you, tracks you, or goes to your neighbor's house to find out about your activities. All of these could lead to privacy issues. Remote tracking, GPR tracking, going, warrantless situations where if you had done it physically, you would need a warrant. Now you're doing it remotely without a warrant. These could all lead to privacy issues. So I think the future is going to be interesting. It remains to be seen what kind of compliances we will have. but we will certainly be more vigilant about our data. We will, when we go to a vending machine and we get a product and we don't see, and we see sometimes it came in a Canadian university, they were going to get candy. The machine didn't give candy, and there was an error machine which said that there was an image taken of the person without disclosing it. So covert situations where you don't know, or you go to a makeup app and you try to figure out and they image your face. So very covert facial recognition apps or even machines could lead to situations where you could legitimately complain of breach of privacy. Having said that, I think we can use the intervening transition period, so to speak, to sort of bootstrap and get compliant ready, make sure we have robust agreements, revisit our data privacy policies, revisit our consents, legacy, as well as what we should be doing, review situations under GDPR which have led to certain pitfalls so that we avoid them. And I think the experiences which Donata has shared with us is helpful in understanding that. And what you mentioned that there could be a lot of areas where we yet to understand who is going to be the right officer. We certainly know that if you're a significant data fiduciary, you would need to have the DPO, somebody in India, but who that will be, we don't know. Maybe a new category of service providers, new category of human resource people to manage such things, just as we have for our BSR, SR, a new category of assurance providers. So I think we are in for some interesting times, and I think we leave it with that thought that going forward, data is going to have a very key part in not just our lives, how we manage our data, but how others manage our data too. And it's not just going to be sufficient to have reasonable security, reasonably secure practices, but also have processes and to be able to demonstrate that we have it. Because many times we are called upon in a data privacy situation that we do have it, but we are not able to demonstrate that we have it, or it was in place, or we trained our employees properly. So I think all of that need to be done, and there's much work to do. Thank you. Thank you, Dr. Bhasin. This has been very helpful and a great summit.
Ms. Leera Goswami, and also special thanks to Donata for having participated, you see, from the farthest corner of the United States. I think now you can have a good sleep at, it must be 4:30 or 5 a.m. in the morning, so you can resume your sleep. So many thanks for participating.
Thank you for having
very useful inputs. And also my thanks to my colleagues here, Mr. Shobhit Chandra and Mr. Samit Gambhir. As always, your presentations have been brilliant. We have heard you many a time, shared the platform with you. Again, it is a pleasure. So a big hand, you see, to the eminent. So I would request my two colleagues here, Mr. Jaipat Jain and Ms. Namita Chadda, to please come here to present our mementos to the eminent panelists here. Donata will keep your memento and have it sent to you.
Thank you.
Questions before we get the mementos, just in case.
Okay.
Ms. Leera Goswami. Mr. Shobhit Chandra. And Mr. Samit Gambhir.
Thank you so much. Now may I also request IACC and IC Secretariat along with our Secretary General, Mr. Kamal Vora, to please join us for a group photograph. I request everyone to please join on the stage. Thank you, Dr. Basin, for such a great summit. Thank you so much.
There is some good spread of high tea outside. Please join us. So I declare this summit as closed. Thank you. Thank you.